Hear ye. The Court of Appeals of the State of Michigan, now second, the Honorable Colleen A. O'Brien, the Honorable Randy J. Wallace, presiding Honorable Philip P. Mariano. All persons having business herein draw near to give attention, and they shall be heard. God save the United States, the state of Michigan, and this honorable court. Good to see you.
Good morning.
Morning.
Yeah, on behalf of myself, Judge O'Brien and Judge Wallace, welcome to the Michigan Court of Appeals. This is panel 4 of the court's July 2026 case call session. And we are ready to begin our 10 a.m. session for the day. Thank you for being with us here today. Just a few opening remarks. Counsel, just remember when you come up to the podium, please be sure to put your appearance on the record. If your clients happen to be in attendance today, let us know that as well so we can welcome them. Counsel, I'll also ask that you keep your own time. I'll do my best to help you, but if you could keep track of that, that would be helpful. And if you have another attorney that you're splitting time with, please advise me of that at the outset. A reminder that in cases where both sides are endorsed for argument, it's a maximum of 30 minutes per side, and where only one side is endorsed, it's a maximum of 15, unless the court is otherwise ordered. Just in general, rest assured that we are very familiar with the relevant facts and law for each case, so please focus your time today on your most salient points or points that you feel were not as clear as they could have been or as you would have liked to have been in your briefing. And finally and importantly, because these proceedings are being recorded and will be posted publicly online, for cases that involve children or other vulnerable or protected individuals, please don't use those individuals' names, but instead refer to them by their initials or some other non-personally identifying way. And lastly, counsel, if I mispronounce your name or your client's name, please do correct me. It's important to get that right. I think that's all for me. So that said, we look forward to hearing your arguments today, and we'll begin by calling item number 1. That's People v. Martin, case number 367173. And this is an instance where we have a bit of a deviation from what I previously said. Counsel, I believe we have a limit of 15 minutes of oral argument for yourself.
Yes, Your Honor. Thank you. And I'll keep my own time and try to reserve 3 minutes for rebuttal time if I go that far. May it please the court, my name is Wade Fink. I appear today on behalf of the defendant appellant, Mr. Colby Martin. It's nice to see you all. Your Honors, I would submit to you that I was one of few 8-year-olds who knew the saying, bad facts make bad law. Both my parents used to say it to me, didn't know what it meant. And I think this is a case study in whether that is true or not. And the reason I say that is, and I'm specifically going to focus on the first issue, Your Honors, but obviously what's important to you is important to me if anyone has questions about the others. But the reason I say that is there are some troubling pieces of information in this case. I'm just reading through the briefs and the record, I'm sure anyone would have been troubled by some of the evidence that was presented at trial. That evidence, however, is the very issue and the very reason why Mr. Martin deserves a new trial. And that is because the evidence that was designed to inflame the passions of the jury rather than for a specific and proper 404B purpose did exactly that. The same thing that it did to probably this court reading some of the facts and reading some of the evidence, and had nothing to do with the intention, motivation, or premeditation that was occurring at the time of this tragic encounter with the car and the decedent. Your Honors.
But your client was claiming accident.
Correct.
Right. So obviously the prosecution needs to be able to meet that.
Correct.
So why is this evidence categorically outside the realm of what could be properly considered, given the dispute that was presented?
Your Honor, I think importantly, when you say the word categorically, just as a threshold matter, each category of evidence needs to be have an independently admissible purpose under 404B. And there's several categories, right? There's the pornography that the nicest way I can say it would appeal to the period interest category. You have the items that were found in the car. You have the post accident or post encounter collision searching. So each one deserves its own category. And what I would submit to answer you, Judge Mariani, is in Exhibit C, the People's Notice of 404B evidence. There is one paragraph dedicated to the purpose of the 404B evidence. And it was just a shotgun approach, basically cover all the categories of 404B. No real delineation of here's what we are going to use, the stun gun that was purchased an hour before the accident happened, or here's the purpose we're going to use him being on a website with models, and here's why we think that's related to motive. There was no delineation of that, no notice that the whole purpose of 404B is so you can litigate these things beforehand. And then we saw that play out, why that's problematic. And the reason we know that is because the people had a shifting version of what really happened here. At first, this was the common plan and scheme. He was driving around with these items. This is a guy who watches weird stuff online, and this was his plan. Then at oral argument, they abandon that and say, well, this became a crime of opportunity. This obviously was outside the plan. And that's why the 404B notice has to be more specific. And that's why People versus Crawford and Vandervliet, the Michigan Supreme Court cases that talk about 404B notices, that's why they say that it can't be just...
Counsel, is it your position that you do a 404B notice, and let's say we are very specific about in the way that you're saying, and then things come to trial and the proper purpose shifts. It's still a proper purpose. It's just maybe a little different than what was in the notice. You're saying that's a problem?
I think
under
both.
404B?
I think both, Your Honor. I think as a threshold matter, the 404B notice was insufficient. And because of that, you had all the problems at trial, including the jury instruction that was designed to be a limiting instruction, but was no such thing. That's in the brief. But I also think on the merits, on the substance, none of this evidence meets any category of 404B. The stun gun, we can use that as an example. The stun gun being purchased as a means to say it was a common scheme or purpose or intent or motive was bought an hour before the collision. Had nothing to do with what his intent was at the moment of impact. And it certainly wasn't a device that was used in the alleged murder. It certainly wasn't a device that could have been used in the alleged murder. It was bought online an hour before. And pile these things up upon each other, it becomes a situation where the people's purpose in doing this was said exactly at closing argument on trial transcript 6, page 47. This is somebody on the hunt in Van Buren County driving around aimlessly in a rural area community, and a crime of opportunity appeared.
Well, wouldn't the stun gun give the individual the opportunity to subdue a victim?
In theory, if this was bought weeks before and delivered to his
Well, what
home,
does it matter if it was weeks before or right before?
because 404B, Your Honor, has to have a direct purpose. And it's not really the defendant's burden to tell you what that direct purpose is. So what I'm stuck here defending is all of these hypothetical purposes for which that evidence was offered, none of which are acceptable. It doesn't show any motivation. Ordering a stun gun online an hour before there's no motive to killing someone. It's not a common scam or
But
scheme.
hypothetically, if somebody buys a stun gun an hour before they end up hitting somebody with their car, isn't that evidence that person had the opportunity to potentially subdue a victim? The fact that they ended up using a car to subdue the person instead of a stun gun, does that somehow take the stun gun outside of the realm of admissible evidence?
Judge, I think that finding, if that was the position of the people in that finding, is such a stretch as to untether 404B from its purpose. I mean, 404B is designed to have a narrowly tailored purpose, and to say that that this was a plan or scheme when something he ordered that couldn't have possibly been used in the alleged murder because it was ordered before for delivery was somehow anything other than saying this is a weird guy with some weird propensities and he probably committed murder. Because that's the implication that they wanted from all of this. That's the implication they wanted from saying he watches weird porn. The implication wasn't that somehow There was no evidence in the record of a sexual assault. He wasn't charged with mutilating a dead body. He wasn't charged with any sort of sexual crime with the victim. The medical examiner testified that after an examination of body, there was no evidence of any sexual conduct. And yet, piece upon piece of evidence of this man's life from his phone, whether strange or not, was admitted to show this is a weird guy who watches stuff that is morbid and strange, and he's prowling around Van Buren County. And when they said that to the jury, that's precisely the reason for the evidence. Not a 404B purpose. It wasn't even articulated for what the 404B purpose would even be. So I think the telling part of that, to Judge Mariani, to your earlier question, is one of the pronouncements of some of this evidence was, that he had been watching pornography that depicted women being asleep. And, maybe that was his strange interest, and that's why he ran down this woman on the side of the road. And then at the closing argument, they say, well, he abandoned that plan and just became a crime of opportunity instead. There was no real 404B purpose. And that's why you have to notify and delineate precisely what you're using. And then the judge can instruct the jury, this is what you can use it for. Instead, the trial court in this case instructed the jury that you can use it for whatever purpose you find appropriate.
It's not propensity, right? And that's what the rule says, right? I mean, 404B is a rule of inclusion in I think is how the case law is characterized. It's like you can't use it solely for propensity, but you can use it for other non-propensity reasons.
No question, but those other non-propensity reasons need delineation and explanation. And oftentimes, as you see in transcript after transcript, these limiting instructions will be what it can be used for, not just carte blanche to consider it for whatever other purpose you want to consider it. And my submission to you is the reason that the people did it this way and piled this evidence in without any delineation is to give that impression, to inflame, to try to explain that the residents of Van Buren County should be afraid of this person. When none of it, on balance, looking at it either as a whole or individual categories, tells you what Mr. Martin was thinking at the time of impact, which was the critical factor in all of this. I think the most direct authority, I don't think it's cited in Sato's brief, but I think this is one that I would ask the court to consider in writing its opinion. People versus Bass, 317 Mishap 241. It's a 2016 case. And it is this Court of Appeals case where the court excluded evidence of a prior sexual assault as motivation for a homicide case. And the court found that such testimony had no seeming relevance, especially considering defendant hadn't been charged with anything related to a sexual assault, in that case, the CSC, which is the same thing here, or any conduct that has to do with sex. The last thing I'll say, and I'll reserve the balance, Judge, I see I'm at about 11 minutes. I'm just going to switch quickly. I think the other three issues, they speak for themselves in writings. There's one thing I want to highlight about the last issue on Miranda, and that is the Seibert and the Illinois cases about the period of time between an improper un-Mirandized statement and then a proper Mirandized statement. If you look at the record in this case, there was virtually no recovery period or time for the later Miranda to cure the prior un-Mirandized statement. Now, we argue to you about the custodial interrogation, that engaging in a conversation that is designed to elicit a response, which is what the police officer, we believe, did, was custodial interrogation. Everyone agrees it was custodial. The question is whether it was interrogation. If you agree, that later Mirandized statement does not cure the un-Mirandized statement, and it's certainly prejudicial. I'll save the balance of what I have left for rebuttal. Thank you. Okay.
Good morning, Your Honors. Excuse me, Paige Petrosky on behalf of the people. I'm primarily just going to focus my time on rebutting and addressing some of the points that were just raised. First, I want to note that the structure, or excuse me, the standard that's actually being evaluated when we're looking at the improper admission of other acts evidence or the evidence of the materials found within his truck, it's not. We're not evaluating, the sufficiency of the 404B notice. We're evaluating whether the trial court itself abused its discretion in choosing to admit that evidence. And it's just based off of the record in this case, it is blatantly clear that the trial court did not abuse its discretion. The trial court very carefully and methodically, piece by piece, bit by bit, went through each of the raised items of evidence to determine which proper purpose it would or would not apply to, what would be appropriate, and what would be fair. And ultimately, although the evidence was determined to be admissible, the trial court even instructed or ordered the prosecutor do not use the term rape kit to describe the items found within his truck. And the prosecutor agreed to that. Well, I should say the trial court told the prosecutor to only reserve the use of that term in closing arguments if the evidence permits, which again is a very reasoned, well thought out and legally valid, I guess, a way to approach. And ultimately, the term rape kit was never used. And so when we're examining the trial court as we are supposed to under the law, it's very, very clear that an abuse of discretion or an abuse of discretion did not occur. As far as the necessity of this evidence of pornography or sexual interests or motivations when a sexual crime wasn't charged, I would just note that having sex or sexually involving oneself with a dead body was not made illegal until after the trial actually occurred in this case, as a result of the victim in this case's husband's advocacy to get that made illegal. There was not a crime necessarily for the sexual violation of a body at that point. And the evidence did not indicate that he had sexually violated the victim in this case prior to killing her. So that just wouldn't make sense. Absent there being a sexual crime being charged, one can still have sexual motivations for why they're engaging in specific acts. And all of the evidence that was admitted in this case was very, very closely tied to establishing what was his state of mind. What was he looking for? Why would this person drive 15 feet off the road with with perfectly clear conditions to kill a woman and then hide her in his truck for 7 hours there's a lot of things that just don't make sense if we don't examine what his motivations are, what his intent is, especially when he was charged with open murder, which intent is obviously needs to be decided by the jury. And so for those reasons, it's very clear that this was relevant, this was necessary information, and the prosecutor is permitted to argue reasonable inferences from the evidence, and that was what was done. And prosecutorial error wasn't raised in this case either, regardless of what her arguments may have been at closing argument. Ultimately, the trial court did not abuse its discretion. It properly applied the law, and it was a very careful measured approach to this very potentially inflammatory evidence.
What about counsel's criticism of the sort of shotgun approach of like, here's every proper purpose on the list, and how does that serve the purpose of the rule and protect sort of the interests that the rule is there to serve?
Yeah, so it is, I mean, I wouldn't deny that it wouldn't be preferable to have a very detailed explanation for the reason in the initial motion, but shotgun approach, it really, when the motion hearing occurred, the prosecutor really focused her argument on the issues of motivation and intent. It was, although other potential proper purposes were discussed, really the focus was on the primary purpose for which that evidence was ultimately used. Okay. If there are no other questions, I will be done. All right, thank you so much.
Thank you.
Thank you.
Your Honors, what I'd ask you to take from that argument is the sentence, the evidence did not show a sexual component. That is what the medical examiner said. That is the reason nothing else was charged. And that is the truth. There was no evidence of a sexual component. So what they did in pushing this evidence to try to pigeonhole that into a motivation of some kind is saying because this guy pays living young models online money for them to strip, somehow that is the equivalent of him being willing to not accidentally, but intentionally and with malice aforethought, run down a woman on the side of the road. Those things don't go together. That's the problem. And that is the teachings of something of Denson and Bass. People versus Bass is the one I quoted, but Denson, there has to be a direct correlation. Judge, you look at anybody's, Wallace, you can look at anybody's search history. God forbid they get in an accident, and it truly was an accident, and try to hypothesize what's going on in their life with why that might have happened. But there has to be some sort of logical tether.
But after the fact, if he's so absolutely panicked, as you claim, that he actually hauls the body away, and in the course of doing that, he's watching those videos, how's that not evidence of absence of mistake? I mean, anybody that was truly so traumatized and petrified as to what they just did is then going to be watching those videos in the process of carrying the body away?
That, I think that's a different category of evidence with different arguments that I was just making. But to your point, Judge Wallace, and I understand it. I don't pretend to know what takes someone out of the mindset of what just occurred and the panic that goes on to it. He also texted his ex-wife he wants to see his boys because he's sad. I don't pretend to know what's going on inside of his brain. What I do know is there's no logical tether between the watching of live women online and paying them and this accident that occurred that the people just said to you too had no sexual component.
But then you're ignoring a lot of the other evidence, pre-accident evidence, which included, viewing websites pertaining to necrophilia, things of that nature. I mean, just kind of sweeping that under the rug.
No, I'm not sweeping it, Judge. I understand that, this is a spectrum of what has some relationship to some 404B purpose and what doesn't. There are plenty of categories here where piece by piece, a lot of these shouldn't have been admitted. On that topic, Judge, again, there is no evidence, as the people just said again, of a sexual component to the crime. So necrophilia or an interest in that was not actually a common scheme or purpose or an absence of mistake or can be said to be a motivation that did not occur. So what is being asked is, this guy is strange and he has stuff in his car that's weird and we don't need him prowling around Van Buren County. I think that's the impression they wanted and the one they got.
You're at time, counsel, unless there are any other questions.
Unless there's any questions.
No,
Okay.
but thank you very much.
Thank you,
Appreciate
Judge.
your advocacy.
I appreciate that, Judge, very much. Thank you. Nice to see you all.
Thank you, counsel.
Likewise.
Okay, that matter will be submitted. Okay, moving on to item number 2, People v. Dawson, case number 368-146.
Good morning.
Morning.
Brad Lyerla. I represent Mr. Dawson. I want to thank the court for the 10 minutes you've given me this morning. I'm not going to reserve any time.
Okay.
We've identified 4 ways in which Mr. Dawson's counsel was ineffective during the trial. His ineffectiveness is why he was convicted. It's a case that otherwise should have resulted in an acquittal. And to remind the court, and maybe to make this more efficient, the first issue is he failed to call an eyewitness who would have exonerated his claim. The second issue is he failed to impeach the principal witness of the prosecution with information in a police report that he failed to find. The third thing is he misunderstood and got himself tied up and was unable to impeach another witness with a prior inconsistent statement because he thought it was an excited utterance and he didn't know the difference between the 2 rules, and ultimately in frustration he didn't get the evidence in, and it was important evidence for impeachment purposes. And finally, he didn't seem to understand the ballistics evidence, which completely undercut the testimony of the principal witness, a man named Michael Johnson, because Johnson's description of how the shooting occurred is impossible to reconcile with the physical evidence that was recovered at the scene of the crime. Now, I don't want to walk through all 4 of those because I only have 10 minutes. So if I might, which one would the court like to hear about first? And if you leave it up to me, I'll talk about the first one. But
Versus the updated, I think Dorsey's affidavit.
Dorsey's
Yeah.
affidavit, right. So as the court will recall, there were hundreds of people were present when the shooting occurred. Only 3 claimed to be eyewitnesses. One was Michael Johnson, who was also started out as a co-defendant of my client. And the other was Tiamir Johnson, the cousin of Michael Johnson. And then finally, Dorsey. So
Is she related to some of these?
no, I don't think she is. I don't think she is. Although if you're familiar with Covert, it is a place where everybody's sort of related. And if they're not directly related, they certainly know one another. So Miss Dorsey was known to defense counsel. She was disclosed to the jury as a person likely to testify during the trial. Trial counsel said in a sidebar to the court that Dorsey was under subpoena and he expected her to testify. And then at the end of the trial, she hadn't been called to testify. The client was stunned, his family was stunned, and Ms. Dorsey was stunned. And so what she did was, I think a courageous thing. She contacted Detective Marlowe, the principal officer in charge of the case, and asked to see him. And he scheduled her, and I think they met 6 days after the jury's verdict. When she met with Detective Marlowe, she gave an account that exonerates Mr. Dawson. She said it was Mr. Johnson who was shooting, that she saw Mr. Johnson shooting and no one else shooting. Why wasn't Miss Dorsey called by defense counsel to testify? No one knows. I don't know. I tried to find out, but trial counsel, who was very, very cooperative at first, handed me off to a junior person in his office. Once I started asking questions that were a little bit uncomfortable, I think he perceived them as uncomfortable. And I dealt with the junior person, and I never got a satisfactory answer with respect to why she wasn't fault. The family was pushing me. I called her myself. She wasn't easy to get a hold of. She was a homeless person at that time. I called her myself, and she told me her story. I tried to get her to sign an affidavit, and she did, but it was logistically, it was not very easy to get her to sign an affidavit and return it to me. Here it wasn't notarized and so forth. I wouldn't have even needed the affidavit if I knew that Detective Marlowe had a long report. I didn't know that at the time I talked to her. I found out about Detective Marlowe's report of his hour-and-a-half meeting with Miss Dorsey later. The report that Marlowe prepared, there's also an audio tape, which is an hour-and-a-half long, so it's not part of the record. But Marlowe's police report prepared based on that meeting is fairly accurate. He leaves out some of the details. I shouldn't say it's fairly accurate. It's accurate as far as it goes. It's accurate, but it leaves out some of the details that make Miss Dorsey's account of what happened even more compelling, at least in my mind. So
I have a question.
yes, of course.
The affidavit doesn't mention whether she told the defense attorney that she had this information or that she would testify in this manner, that she actually told trial attorney.
So Marla's report indicates that she admits that she had talked to defense counsel. Defense counsel admits that he had talked to her, at least insofar as defense counsel said, I've got her under subpoena and I expect her to testify. That took place. That comment was made to the court during the trial at a sidebar. So clearly defense counsel knew about her, had a plan for her. And I'm an older lawyer. I just can't, I've tried a whole bunch of cases. I just can't imagine why she wasn't called to testify. And so I understand the prosecution's arguments. I mean, clearly she had some issues that she would have been cross-examined about. But every witness in this case had witnesses. I'm sorry, had problems that they were going to be cross-examined about, because everybody, the first time the police came to any one of the witnesses, even the prosecution's witness, they all denied knowing anything. It's what me? No, I don't know anything. And so everyone was subject to the same sort of cross-examination. And I just if Miss Dorsey had given the testimony that she gave to Detective Marler after the verdict, this would have been a very, very difficult case. This is just an absolute powerful case for reasonable doubt. And mostly because of Micaiah's testimony, but also because when Michael Johnson testified, he claimed that he didn't care about the fact that there were rumors that his wife had been unfaithful to him with Mr. Hunter, the victim. And that just was preposterous. But defense counsel was unprepared to cross-examine him because he didn't find this police report that was just dynamite. It was just, that should have been just a tremendously powerful moment in the trial. And he's missing in action.
About, is it TMR?
I think that's how she says it, TMR. So TMR, right after the shooting is heard by another witness, a woman named Matera Frazier. Frazier hears TMR say, "Bruno done it." And I think that's what she said. Bruno done it. And Bruno's Michael Johnson. So right after the shooting, TMR says, "Bruno done it." When the preliminary examination happens, she testifies that she saw Mr. Dawson shooting. That's her preliminary examination testimony. Then at the trial, she says, "I don't remember who was shooting. I don't deny that I said in the preliminary examination that Mr. Dawson was shooting." But there's this statement immediately after it happened where she said, "Bruno done it." Now, trial counsel thinks that that's an excited utterance and therefore an exception to the hearsay rule. So when Tiamir's on the stand, he tells the judge in a sidebar, he tells the judge, "I'm going to ask her for a statement that might sound, when I first asked the question, might sound like hearsay, but I think it's an excited utterance." And the judge was confused. And the prosecutor was confused because they both thought of it, and it's very clear from the record, they both thought of it as a prior inconsistent statement. And the prosecutor said something about, "Well, you have to lay the foundation because it's prior inconsistent statement." And trial counsel didn't understand that and stuck with this idea that it was an excited utterance. So
Isn't it both?
well, I don't think it's both. In fact, and one of the problems, and I'm not arguing that it's both. In fact, I'm arguing it's a classic prior inconsistent statement.
For sure, but why is it not an excited utterance?
Yeah, it's not an excited utterance because the cases are really tough on excited utterance, and it wasn't close enough in time. She wasn't close enough to the actual shooting, and there are all these reasons why I think Judge Brickley would not have let it in as an excited utterance. And Judge Brickley was pushing back on the excited utterance concept.
My job requires me to tell you you're at time.
Oh, I'm sorry. I'm sorry. I could go
So,
on forever.
unless there are further questions from my colleagues.
Go ahead.
The only thing I would have is, was there some kind of writing or is it in the police report that she made that statement, "Bruno done it"? Is there?
That is not in any police report.
All right.
That was a witness who did testify later, but trial counsel did ask her the question later because he was befuddled by the fact that he didn't have any cases that he could cite for excited utterance, and he just didn't know the rule for prior inconsistent statement, evidently.
All right.
Thank you.
Thank you, Counsel.
Thank you.
Hello, Paige Petrosky on behalf of the people. So discussing the ineffective assistance of counsel claim related to Ms. Dorsey. First, when we're get my thoughts. So first, trial counsel was very much aware of Ms. Dorsey. He had subpoenaed her. He had her, he had stated on the record that he was planning on calling her. And there is no, if he had a plan that would be considered a strategic plan to call her as a witness, the only assumption or the only conclusion one can come to by his change of mind or his change of strategic determination of whether to call her as a witness or not is that that was a strategic determination.
Well, that's not the only thing. I mean, he could have just dropped the ball, right? And
He could
also
have,
he
but
could have
trial-
made an unreasonable strategic decision as well, right? I mean, how does the present record really allow us to make an assessment on this constitutional question?
Well, trial counsel is presumed to be competent, and the determination of which witnesses to call is the paradigmatic example of what is a strategic decision. Who should be making these statements, and also it really, when we look at the variety of explanations or statements that Ms. Dorsey had given over time, the record is unclear. It's unestablished as to what she would have even testified to. Would she have given her original statement, which included details that were demonstrated false by the testimony at trial? Would she have given her new statement? We have to evaluate the appeal based off of the record that exists. And ultimately,
You can also, I mean, we do have options, so to
we do, but
say, hey, we need more record here to really understand what happened to properly evaluate these claims. I mean, it's a nice feature of Michigan law, and so I guess why is that not appropriate here?
well, because of the time, excuse me, the I guess stage that we are in, the trial court, it did not abuse its discretion when it denied the Ginther hearing. And so if we're evaluating whether or not we're discussing whether or not it was an abuse of discretion to deny that Ginther hearing. And the trial court, when evaluating the evidence placed before it, evaluating and accepting into the record the tardy evidence that was submitted after, post the motion for new trial, motion for Ginther hearing, the trial court considered all of that evidence and found that defendant was raising primarily legal issues. There was not a specific instances of things that needed to be established or developed on the record. And that reasoned approach, again, was not an abuse of discretion for the trial court to come to that conclusion. And so also looking at the Dorsey statement, excuse me, in the police report that, again, was accepted into the record by the trial court, even though it did not have to, as it was a tardy filing, Ms. Dorsey told police that trial counsel had spoken to her and told her not to testify, that thereby indicating this wasn't something that that he had just, it slipped his mind. He forgot to call one of his 3 witnesses. This was something he specifically called her and intentionally told her to do. And this is what we have in the record now. And she, as a part of that conversation, asked her why she had not spoken to police when they had tried to get in contact with her. And that was a part of trial counsel's strategy, was to argue, that the people's witnesses, their statements evolved over time, or their hesitancy to speak with police, that made them unreliable or uncredible witnesses that would inject reasonable doubt. And so were he to then go and call someone who has made at this time has made a statement that is not necessarily helpful to the defendant's case, or it's unknown exactly which statement she was going with at that point in time. But at that point in time, we don't know what she would have testified to. And so, but we do know that trial counsel was concerned that she hadn't spoken to police and hadn't cooperated. And that was a point that was made an issue with the people's witnesses later on at the actual trial. So it's a logical extension of, oh, okay, I'm making this argument about why the people's witnesses are uncredible. And I should not call a witness who has those very same potential issues with credibility. And so based off of the record that we do have, it's very clear that this was an intentional decision made by trial counsel, and a reasonable strategic decision made by trial counsel as well. The moving to the Michael Johnson domestic violence conviction, essentially, again, this is not a circumstance where trial counsel was not aware of Mr. Johnson's prior convictions or aware of. It's very clear he knew what his prior convictions were. He had a strategic approach for which convictions he was planning on introducing at trial, and then ultimately, it's not clear, or I think even possible, that this would have been admissible as a prior inconsistent statement. It does not directly refute the statement that was made. And so,
I mean, isn't the theory that, he testified about how this is not how he would react to finding about infidelity from his wife. And then you have, hey, weren't you charged with domestic violence when you found out about your wife being unfaithful to you? I say, so why is that not admissible as impeachment, or under some other, theory?
So the specifics of what he actually testified to, that this prior conviction would be used as a to refute or to undermine his credibility with, he was specifically stating that he would not take out, or he would not get violent, or he would not kill the person that that he believed his partner was cheating with. He would not take that out on the sort of the other man. Whereas in the domestic violence conviction, that is him specifically taking out those violence that out on the woman, the partner themselves. And that's different ultimately. I mean, I get that they're similar in nature, but it's really whether or not who you are going to exact violence on is important when there is a person who may or may not have been involved romantically with his partner versus, the victim in the case at issue was not Mr. Johnson's former romantic partner. So ultimately, he's not saying the two are similar, but they are not one. The domestic violence conviction does not directly refute what was actually stated at trial. And then I would just say that the discussion about Timir Johnson, with that, there is discussion about whether it would be an excited utterance or a prior inconsistent statement. It could have been both. It could have been neither. Ultimately, trial counsel decided to impeach Ms. Johnson's testimony via another, more reliable manner by attacking her memory, attacking very substantial things, attacking the reasons why she had some inconsistencies. And so essentially, it was a strategic decision where he may or may not have felt that this was the most effective way to approach impeaching her credibility, and ultimately chose another route. And also looking at the Strickland analysis, prejudice and performance and prejudice, even if this court were to find that that was deficient performance, in the face of all of the other evidence in this case, where you do have people who saw what occurred, you had inconsistent statements from defendant, you had the ballistics evidence stating ballistics and the forensic examination evidence. All of this together does not make it so that the trial counsel's failure to impeach Ms. Johnson's testimony in this one specific manner, it really can't be stated that that was an outcome determinative issue, even if there were to be, even if this court were to find that there were deficient performance. Let me just check my notes real quick. Are there any questions? I am all set.
Actually wondered if the panel wouldn't mind if I asked Mr. Laierla a question.
Sure. Yep. Thank you, counsel.
Thank you for your time.
Yeah, thank you.
Yes, sir.
So I'm just wondering what your reply is to her position with regard to Johnson and the domestic violence prior charge.
That would not have been admissible to put in as a prior act to somehow undercut Mr. Johnson. But it was admissible. I think Judge Mariani sort of nailed it. It would be admissible because he volunteered in his direct examination that he doesn't care if his wife is unfaithful. And he's saying that, I don't remember exactly, but 11 months after he was arrested, and in the police report, he was caught beating his wife in the backyard, yelling, "I know you have another man." So how is that not impeaching, for crying out loud? If you'll forgive the.
So you're saying that the distinction that counsel is drawing in terms of sort of who the violence was directed toward is more of a weight issue than an admissibility one?
Yes, I guess that's what I'm saying. Well said, Your Honor. That's you said it better than I said it.
Yeah, thank you.
Your question? Okay.
Thank you.
Thank you, counsel.
Thank you both.
All right, that matter will be submitted. Okay, moving on to item number 3, People versus Madden. That's case number 377890.
Good morning. May it please the court. Michael Nichols. I'm here on behalf of Nicholas Madden, the appellant, and we'd like to reserve 3 minutes for rebuttal. So the rule of law that we're asking for from this court is that just because an investigation begins in public does not automatically allow law enforcement to continue that investigation in private in a constitutionally protected area, such as the curtilage, as is the case here.
So is it a race to the house or, explain that to me. Is that just a home base kind of theory? Like the police put on their flashers and I say, okay, well, I'm close. So I just go for it. And then once I'm there, the rules change entirely.
And I understand that's a big concern that, courts have said, you're just letting people run to their safe harbor, their home. Cops can't touch them there. And that's really the way the Fourth Amendment, when it comes to protecting the home, has been applied throughout decades and centuries. And I wouldn't really look at it as a race to the house. I would look at it as, the facts are what they are on any given circumstance. And, here we have a misdemeanor. It's, Officer Devereaux gets a be on the lookout or a BOLO for a potential drunk driver because somebody reports this Tahoe driving south near the city of Grand Ledge and it's weaving all over the road. So she finds a Tahoe also traveling south in Grand Ledge. She gets behind it and she testified. It's joint exhibit. Appendix A, the preliminary exam / motion hearing transcript. I turned on my lights. I knew he was turning into his driveway. She was waiting to try to get more probable cause.
But it takes, we've seen the video, the dash cam video, and it takes between 9 and 10 seconds from the time she flashes her lights to the time he pulls into the driveway. So the Michigan Vehicle Code is very clear. When an emergency vehicle flashes their lights, it doesn't say, get to a spot where you're out of their way. It says you have to pull over parallel to the road. And it actually explicitly says you have to do it immediately. So how did he even have the right? And he can't really claim he didn't see him because it's in the middle of the night. They're the only vehicles on the roadway. She lights him up. How does he even have the right under Michigan law to do anything other than immediately pull over to the side of the road?
And the officer had two choices that were constitutionally sound. She could seek charges.
I'm not asking about the officer. I'm asking under the Michigan Vehicle Code, your client is he's operating this vehicle.
Sure.
The law is explicit. It says when the lights go on, and it doesn't necessarily even mean you're being pulled over. It's a very broad but very explicit statute. It says when those flashers go on behind you, you have to pull over to the side of the road immediately. So how did he even have the right to continue to travel under our law?
And she could have given him a ticket for that, left it on his truck.
So you agree then he did not have the right to keep going?
And I agree, and I don't think that really applies to the curtilage analysis, because the fact of the matter is he got to his driveway, and 9 to 10 seconds, is in the eye of the beholder. Does it seem like a lot? Does it seem like it's not a long time? And what's the driver thinking is the safer spot for him to go, whether it's more safe for both him and the law enforcement officer to get to a driveway off the side of the road without knowing, as the court put it, Judge Wallace, that the statute's pretty broad, not knowing what the statute is. The fact
Look, when I say broad, I mean it's broad in that it doesn't just apply to a police officer.
Sure.
It applies to any emergency
Sure.
vehicle. So it could be a fire engine, it could be an ambulance, anything that has the legally recognized overhead flashing lights.
Sure. And understood. So he gets to his driveway, a constitutionally protected area. He's within feet of his side door and his garage bay door. And when the officer, I have no quarrel with the officer approaching the truck. All of our jurisprudence on curtilage says any member of the public can walk up to the door, knock, wait for the opportunity or invitation to linger longer, like the Jardines court put it. But once you're told go away, you go away. And that applies to law enforcement and members of the public equally. And that's what happened here. Mr. Madden said, I'm in my home. I'm not getting out of the truck. Go get your warrant. And that's what she could have done, which is what she did do. We know from the preliminary exam transcript at Exhibit A that Officer Devereaux did indeed go get a search warrant. I want to address the People versus Schenkel case that the prosecutor cited in their response. And the reason why I think Schenkel is not applicable here is because there were two major differences. In Schenkel, there was a voluntary cooperation type of encounter between the Eaton County Sheriff Deputy, ironically, two cases out of Eaton County, and Mr. Schenkel. The officer approached the car, asked him some questions, and door gets open, and next thing you know, the officer sees a gun and makes an arrest. There was no, and since you looked at the video, you can see this was anything but a voluntary cooperation type exchange between the officer and Mr. Madden. Secondly, in Schenkel, it wasn't even Mr. Schenkel's home. And in the opinion, it's right there in the findings of the court. Mr. Schenkel told the officer that it was not in his home. In fact, I think it was his brother's home. So Schenkel is not applicable here. And I just think the Lyons case is a square peg in a round hole. I'm asking the court to reverse and remand to the trial court for further proceedings. The relief that we're specifically requesting is dismiss the resisting and obstructing charge under the jurisprudence that you have the right to resist an unlawful command from a law enforcement officer. And whether he failed to stop in compliance with the vehicle code or not, I mean, the officer could have given him a ticket for that. The officer continued.
Well, did the defendant in Schenkel fail to stop? Was the defendant Schenkel ever seen by the officer on the roadway?
That's not anywhere in that opinion that I read.
Well, the answer is no, right? The officer came upon that vehicle when it was already parked in a driveway.
Right.
Yeah.
The other part of the relief that we're requesting, and because there are two counts here, the felony resisting and obstructing, but also the misdemeanor operating while intoxicated, the officer did get a search warrant. And so the relief that I'm asking for is to remand with instructions that the trial court analyzes at what point the officer needed to go get a warrant. There were things in the affidavit, this isn't necessarily part of the record, that were observed by law enforcement after the moment where Mr. Madden said, go get your warrant, I'm at my home. I'm asking for the remand order to include an analysis of the point at which that occurred, and then strike anything after that from the affidavit for the search warrant and determine if the warrant still is supported by probable cause. Thank you, Your Honors.
Thank you.
Thank you, Counsel.
Good morning, Your Honors. May it please the court. Christopher Candela appearing on behalf of the Eaton County Prosecutor's Office. Just so the court is aware, present with me today is Seth Emil. He's a high school senior in high school, interested in attending law school, so he's shadowing me for the day.
Welcome.
I think you hit the nail on the head. What the defense is really asking for is a safe harbor rule here, and I think our case law answers that question. That's not appropriate, especially under the facts of this case. We have.
Well, it seems like, I mean, I guess maybe safe harbor in a certain sense, right? But I also understand counsel's not arguing for, total legal immunity. As counsel conceded, there are, other options under our law for punishment for courses of conduct. And, what we're talking about right now is sort of what is the Fourth Amendment component of this, and how does that interact with how the officer could engage with the defendant in this case?
Correct. And I think because when the stop occurs in the public roadway, at that point, that individual is seized. And that's under the Lyons case. When they continue to drive into their driveway, same as driving into a parking lot, you're inviting that officer to follow you to complete that investigation. If we're saying, the officer could have wrote a ticket for failing to immediately pull over to the side of the road, how do you write that ticket without making contact with that driver? Unless the idea is that the ticket is going to be left somewhere by the curb, which seems unreasonable. Plus, the officer also needs to verify who the driver of the vehicle is to know who to write that ticket to. I think there's in that sense, there's a level of consent there because the driver of the vehicle knew that they were being pulled over, continued to travel to their driveway, knowing that that officer was going to follow them to conduct that roadside investigation. The other aspect of this that I see is, I guess it's really the risk of that sort of rule that once you're in the curtilage of the home, the investigation has to stop. Because in a situation like this where you're dealing with a drunk driving, in this particular case, the defendant pulled into the driveway, attempted to get out of his vehicle to go to his house, and the officer ordered him to remain in his vehicle. Had there been a requirement that the minute he pulled into his driveway, officers have to terminate their investigation, go seek a search warrant, and then come back, there's such a risk of destruction of evidence at that point because take away even the dissipation of alcohol in the blood, there's a clear opportunity for an individual to enter their home and begin drinking, which would destroy the reliability of any blood alcohol test at that point. So there's a lot of I guess state interest in allowing that investigation to continue rather than putting that break in that investigation. The curtilage analysis is very different from and really the courts have already said that the driveway is not a safe haven from OWI investigations. In the Ray case, that was essentially the holding of the Court of Appeals. So in that sense, applying that case,
There was no Fourth Amendment analysis in that case, though, right?
there was no Fourth Amendment analysis in that case. That's correct. The entire focus of that case was really on whether or not the driveway was an area accessible to a motor vehicle.
And there was, if I remember correctly, there was also no assertion that that person had pulled all the way up next to his or her house either, correct?
Correct. In that particular case, I believe the individual was backing out of the garage and stopped right next to their house when they noticed the officer. And I believe the brother counsel has argued in his brief that what distinguishes that case is the fact that the officer was there for, I think it was a noise dispute, a domestic, some other reason that he happened to be present in the driveway. And I think that the analysis is not the reason why the officer is lawfully present. The analysis is whether the officer is lawfully present. And in this case, I'm not aware of any case law that says that the officer has to be lawfully present for a reason unrelated to the arrest, because oftentimes that's the reason the officer's there. Just so happened in that case, he was called out for a different reason. And I think the same thing in this case, the officer is lawfully present in that driveway because they are continuing a seizure that has occurred on the public roadway into the driveway. It happens to be in the curtilage, but that is by the defendant's own actions. I take that, and what I would ask the court to adopt is that is essentially an invitation by the defendant to enter that curtilage and conduct that investigation there rather than in the roadway.
So would you concede that the hot pursuit exception doesn't apply here since there's no suspicion of felonious conduct?
In this particular case, yeah, that's not really an argument that I'm making. I think you can make an argument for it, right? Because you have an individual at that point who has essentially, granted it's like 9 or 10 seconds here, but that individual has essentially attempted to flee and elude a traffic stop. At that point, they did not immediately pull over. They continued to drive to a location.
But the problem with that is the officer never testified to that. She said the resisting and obstructing came from him refusing to get out of the car, not because he waited 9 to 10 seconds to pull over.
Correct. Yeah, I absolutely. And that's why really I think the hot pursuit was raised in the trial court level. It wasn't really the highlight of it, but I focus my argument here more on where the seizure occurred, the continuation of that investigation into the driveway, whether or not there is appreciating that Ray doesn't do a Fourth Amendment analysis. It does indicate that the driveway is not a safe haven from a drunk driving investigation.
Yeah, but if the defendant never raised that in that case, why are we even talking about right? I mean, if the court didn't decide that, certainly not dispositive here, right?
It's not dispositive by no means, but I think it's certainly part of the analysis, and that if we've said that the driveway is open to motor vehicles, and allowing that investigation to take place, I think it indicates that there is, as long as the officer is lawfully present, there is not a curtilage issue, not a Fourth Amendment issue. And I think that's really the crux of Fourth Amendment analysis is the officer lawfully present. And I would argue in this case, the officer was lawfully present because they initiated that traffic stop in the roadway and were invited into the driveway through the defendant's conduct. Happy to answer any other questions the court may have.
Anything further?
Nope.
Thank you, counsel.
Thank you.
Can you maybe start by responding to that last point? He says basically, if we look at Ray, and Ray says that that an officer in your driveway is lawfully present for the reasons we talked about earlier. So the whole curtilage issue perhaps doesn't apply. What's your response to that?
I think in Rhea, there's a real big problem with applying Rhea to this case. And I think the trial court got it right. I'm not sure the vitality of the opinion is got a lot of life left. But in any event, with Rhea, there is no discussion about whether Mr. Rhea told the officer go away, simply in the opinion and order that the gentleman didn't do standardized field sobriety tests, or SFSTs, which is not terribly uncommon in drunk driving trials where there are no SFSTs because the person just stopped doing them or couldn't do them or what have you. So that's why I think that Ray is inapposite. And I also think that in light of Lang versus California from the Supreme Court of the United States, I don't think Ray has a whole lot of shelf life. I think that the trial court and the Court of Appeals were right. And in any event, I want to make it clear, I'm not advocating that the investigation has to stop. She could go up to the truck, knock on the door, open the door, say, hey, I want to talk to you. And he says, no. Okay, maybe at that point, she's able to see bloodshot eyes that she can put into an affidavit for a search warrant, detect the odor of alcohol, and maybe she notices slow movements. She could put all of that in an affidavit for a search warrant for blood and still attempt to get what is, the big hammer in most every drunk driving prosecution, and that is evidence of a chemical analysis of a person's blood. And again, she still was able to get a search warrant in this case. The investigation doesn't have to stop. And she could, absent anything else, if she wants some comeuppance for the defendant that night who wouldn't stop within 9 seconds, she could sit in her car in the driveway, write as many civil infractions as she thinks she's got probable cause for, walk up to either the truck if he's there or the door. If he won't come to the door, she can leave the tickets there. And she could still contact the Grand Ledge City Attorney and say, okay, I think I've got an OWI. I need an affidavit first. I need to get a search warrant done. I also think maybe he didn't stop. There's a Grand Ledge City ordinance that's not necessarily fleeing and eluding. It's failing to obey a law enforcement command. It's also a misdemeanor. Can we charge him for that?
Well, what about the constitutional implications of, I think, opposing counsel says this is effectively like an invitation or consent. You're on the public road, the flashers go on, the law tells you what to do, and you choose to do something else, which is go home with, with the police tailing you. So, I mean, why does that not have constitutional relevance to whether what happens next is protected by the Fourth Amendment?
Because just like in Lang, and the only difference with these facts and Lang versus California is in Lang, the gentleman pulled all the way up into his driveway. I mean, that was still, the officer observed some obstreperous conduct, blowing his horn, yelling out his window or something like that. I mean, there's nothing that stops law enforcement from pursuing a prosecutor to authorize a complaint and a warrant for what they were able to observe. And there's nothing that stops the officer from analyzing whether or not there's an exception to the warrant requirement to stand at the door or try to enter the home. As Lang put it, the flight of a suspected misdemeanor doesn't always justify warrantless entry, but an officer must consider all the circumstances in a pursuit situation to determine whether or not they have to go get a search warrant or they've got, something along the order of an emergency. And on many occasions, the officer may have good reason to enter, but absent anything else, just because a misdemeanor flees doesn't mean the officer is absolved from the requirement to get a warrant. And I just want to make one more point about the evanescence of alcohol in human blood. We've cited a couple of cases, Missouri versus McNeely, and I believe the Wisconsin versus Welch case there. I've read them all and there is too many to cite. There's such a misperception and misnomer about blood alcohol and that, 15 minutes, that guy gets to sit in the house before I get my warrant, 20 minutes, 30 minutes, he's going to be under the limit by the time we get a blood draw, by the time we get a needle in his arm. That's just not true. The courts have recognized that you drink, you stop drinking, at some point you plateau and you start eliminating, and you eliminate at a straight line. There's nothing you can do to speed that up. You're not going to go from 0.15 at 1 a.m. like we have. I don't know I forget if Mr. Manning was 0.15, he's maybe a little bit less than that. You're not going to go to 0.07 at 2 a.m. It's just not the way that the human body works.
Is that responsive also to the concern that, officer leaves to get a warrant, he says, I'm going to go inside, I'm just going to drink a lot. And then how does that, are you telling me that there's not an argument that's going to be made by his counsel thereafter to challenge the blood test results based on that, saying, no, those results aren't reliable because this is reflective of what happened after the encounter?
Right. Let me answer that from a practical standpoint. It's sort of I don't want to use the term sophisticated, but, not everybody knows, okay, if I go in my house and drink or tell the cops I drank, I'm going to have an automatic parachute.
Sure, but on these facts, though, I do believe there was some exchange. Your client, represent the officer. I know how this game works, or something along.
I know
those
how
lines.
this works.
Yeah, and which I'm not sure that necessarily is.
Yeah, and I don't think this is any big secret. If the court looked at the ROA carefully, this is a second offense, drunk driving charge. But in light of that, if there's a concern about some rule of law that gives everybody this parachute by saying I went to my house and drank, the founders, I guess, never really contemplated that when they drafted the Fourth Amendment.
Well, that person would be taking quite a risk as well, right? Because, a jury doesn't necessarily have to believe you went in your house and started drinking.
Right.
That could take that person from a regular OWI to a super drunk.
Right.
Or something along those lines.
Right. And you go from let's say a 0.14 to a 0.24, and then the prosecutor says, imagine how much that guy had to have had drank. That can't be true. He's lying.
Yeah.
So it does cut both ways. Thank you, Your Honor.
Thank you.
Okay. Thank you, counsel. Okay, and that matter will be submitted. Moving on to item number 4. People v. Ozentoski. It's case number 374610.
I'll begin. Good morning, Your Honors. Tracy Gittleman for appellant this morning. I'd ask Your Honors to view the facts of this case, considering policy considerations of OV7 being watered down by the trial courts, scoring 50 points when the conduct does not justify the scoring. The legislature did amend OV7 in 2015 that became effective in 2016 to make sure the trial courts looked at the 4 prongs, but the 4th prong to be similarly egregious conduct to either sadism, torture, or excessive brutality. And they did that to make sure that OV7 would not be scored for conduct that didn't deserve the scoring, because obviously 50 points does increase the advisory guidelines exponentially. That's a large increase, 50 points, and that would normally increase most guideline scoring to the highest minimum. So using the policy considerations and looking at the facts in this case, what do we have? We have assault and battery is basically what domestic violence is. It's assault and battery. And what is the conduct that is being judged by the trial court? That is assault and battery, or that my client did do. We're not disputing it didn't happen, but we're disputing the fact that it doesn't rise to the level of anything in OV7. Now, obviously, I think we can all agree that the conduct at issue is not sadistic, is not torturous, it's not excessively brutal. So the issue becomes, is it the fourth prong? Is it something similarly egregious to sadism, torture, or excessively being brutal? The facts point out that there was shoving, which is a battery. There was throwing or knocking out a phone, which is a battery. And then there was lifting of the computer monitor over the head by my client without ever saying, I'm going to throw this at you, where the victim, the grandma, did perceive that as he was going to throw it at her. Technically, lifting.
There was also a threat, a death threat.
There was also a threat to kill, correct. Coupled with the grandson being present.
Minor child present.
Yes, correct. The issue, though, and the reason I cited the People versus Leidick case is because if we go down the path of a threat to kill means we score OV7, in my experience, that would be the majority of the cases that I handle as a court-appointed appellate attorney, because there's not many cases out there, and it's a range of cases, whether it's assault and battery, whether it's domestic violence, whether it's criminal sexual conduct, armed robbery, unarmed robbery. The threat to kill is very common. It's not an uncommon situation that an accused makes this threat. So do we go down the path that a threat to kill automatically scores OV7? I hope not, because that would mean that the majority of cases now would score OV7 at 50 points, putting accused.
But that's not this case. Sometimes.
No.
I mean, that's one piece of the conduct. So we have a collection.
We have a collection, Your Honor, I agree. And with the collection of the case, the facts here, it still does not rise to the level of the type of conduct that would score under OV7. I will point out in the Leidick case that there was the death threat, and the court specifically handled the death threat issue. But there was the difference between that case and this case is that there were multiple threats, repeated threats during the commission of the crime, which the repeated threats with the young son seeing that the youngster would find the victim's dead body the court found did substantially increase the victim's fear and anxiety. In this case, there was one threat, and it was during the entire commission of the assault and battery. And the son ran out to call the police. And it was a very short burst of violence that involved shoving and knocking a phone out of her hand and the threat. And I don't believe that, based on the case law that I've cited, and that this conduct would justify scoring OV7 at 50 points, as it is not similarly egregious conduct that goes beyond to substantially increase the fear and anxiety of the victim beyond the offense that he pled to, which was assault and battery. Assaults can include threats to kill. It's putting someone in reasonable apprehension of a battery. And battery obviously can encompass that, but the battery here was shoving and knocking the phone out of her hand.
Yeah, what he pleaded to was the push.
He pleaded to a push.
That's all you needed for the offense.
I'm not disagreeing that he pleaded to the domestic violence, which is assault and/or assault and battery, committed those crimes. But did he commit those crimes to be scored to justify OV7, which would have been either sadistic, torturous, excessively brutal, or similarly egregious to sadism, torture, excessive brutality designed to substantially increase the fear and anxiety. She was scared. Anybody would be scared. It's not fun to be assaulted and battered. The majority of victims that undergo this type of conduct are scared, but that is something that is presumed in the crime. And what he didn't do it to substantially increase her fear. He did it because that was part of the crime that he was doing, which was being assaultive, battering, domestic violence. Can I ask for any questions, Your Honors?
No, thank you.
Thanks, Counsel.
Thank you.
Good morning. May it please the court. My name is Emily Schnard. I'm an intern at the Lapeer County Prosecutor's Office, and under this court's approval and Court Rule 8.120, I represent the people of the state of Michigan, the appellee in this case. And pursuant to court order and the court rule, I'm accompanied by Chief Assistant Paul Walton.
Welcome.
Thank you. The trial court in this case properly scored the highest number of points, as it is statutorily mandated to do, when it found the facts of the defendant corroborating a death threat through the force of a weapon, preventing the victim from calling 911, all in front of the defendant's 9-year-old child, to be beyond the minimum conduct required to commit a domestic violence, and similarly egregious to sadism. OB7 requires that a victim was treated with sadism, torture, excessive brutality, or something similarly egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. I'm going to start out with the minimum conduct required to commit a domestic violence. A domestic violence is a simple assault and battery with a relationship element, and in this case, it's a domestic violence third offense, so the defendant had 2 prior assaultive crimes or domestic violences. The defendant went well above that minimum conduct required, the baseline level here, after he shoved the 77-year-old victim, when he used a weapon, the computer screen, and threatened to kill the 77-year-old victim, after he didn't allow her to call 911, which made the 9-year-old child present run next door to call 911. The people also argue that these facts, this combination of facts, are also similarly egregious to sadism, as this court has repeatedly held, and People versus Leidick is cited by the defense and the people. Death threats, the use of a weapon, and child welfare were all involved in that case as well. And this court held that death threats are at a minimum similarly egregious to sadism. And in fact, this court also held last month with Judge Mariani presiding as the presiding judge in that case in People versus Winans from June 22nd of this year, that death threats are again at a minimum similarly egregious to sadism. And in that case, the defendant also isolated the victim from calling 911, and this court found 50 points to be properly scored under OB7.
So, counsel, are you arguing that anytime there's a death threat, we're getting 50 points under OB7? Or is your argument that is a relevant consideration, although maybe not always sufficient in itself?
It's definitely a relevant consideration in this case, and in both cases, there's a combination of facts with the death threats as well to score 50 points. The 50 points for the death threats is at a minimum what boosts it up to be that level, but I would argue that this is very similar to People versus Leidick in this case.
Now, People versus Leidick also involved, I think you could say, a greater degree of violence. It's a more violent encounter. What do we make of that? When we look at what happened here, which, undoubtedly a disturbing event, but, perhaps didn't involve the same degree of, physical violence, physical harm. How do I know that 50 points makes sense here the way it does there?
Sure. And in People versus Leidick, the crime at hand was an assault, great bodily harm through strangulation. And OB7 requires that the defendant goes beyond the minimum conduct, the baseline for that offense. So there are different levels of assaultive crimes here, this being a domestic violence, a simple assault, which death threats aren't really, as opposing counsel mentions, death threats can be part of an assault, but in this case, they are above that level of the simple assault, I would argue.
So you're saying Leidig, it's a defense specific inquiry ultimately. So what's maybe sadistic or excessively brutal for one underlying offense, maybe isn't for the other because the underlying offenses themselves are different. Am I understanding correctly?
Could be, yeah. With the underlying offense, it matters. Just that baseline level, I would really
The
argue.
baseline level, you're right, because for some offenses, you need to commit a lot of violence to commit the offense, and then you need to do even more
Right.
to be excessive.
I would agree. Another requirement of OV7 is that the defendant intended to substantially increase the fear and anxiety that the victim felt. The victim and the child in this case did see physical manifestations of this fear and anxiety. The 77-year-old mother knew of the history of the defendant, of his past violent behavior, so she was fearful of her life that way.
Now, how relevant is it? There are OVs that talk about, they score for psychological injury to the victim and all that sort of stuff. This OV seems more oriented towards the defendant's conduct and choices. Was the conduct designed to do this? So how much can we make of, the manifestation of that fear in the victim, or, even another step removed, the child? The child is not obviously the subject of the crime. So how much does it matter, the proof of that harm for purposes of this OV, given its focus on sort of the conduct and what it was designed to do?
I think that it goes to show the defendant's intent here. With his holding the computer over the head, which I would argue is a threat, he did intend to make the 77-year-old mother in fear for her life with it. This is just a physical manifestation of it, that she sought doctor care for high blood pressure. She refused to make a statement because she was scared of retaliation after the event, which is not normal in a domestic violence. I would say that the victim is this scared, but yeah. This court should also look at this under first for clear error to see the fact-finding issue of the trial court. However, this is the trial court applying the facts to the law, so it's statutory interpretation under a de novo review. But under a de novo review, the people would argue that the 50 points should properly be scored. With the combinations of events here, this court has very recently and continuously held that these combinations boost it up to the 50 points under a similarly egregious standpoint.
Anything further? Okay.
Thank you very
Very
much.
well argued. Thank
Very
you.
well argued.
Thank you.
Very quickly.
Yeah, please.
If the facts of this case score OV7, 50 points, which is the victim stated the defendant pushed her and grabbed a computer monitor, raised the monitor over his head, and she thought he was going to hit her in the head with it. She then picked up her phone to call 911, and then the defendant smacked her hand and knocked the phone down, saying he was going to kill her if she called 911. The victim was asked to provide a written statement, but she stated no because she is afraid that the defendant would retaliate. First of all, that's very common. I see it all the time that victims don't want to say anything after the fact because they're afraid. Very common in domestic violence and very common in those types of cases. But if these facts are scored OV7, then basically every case will be scored OV7 because these facts are not sadistic, torturous, excessively brutal, and they are also not under the fourth prong either. So I just don't see that these facts rise to the level of OV7. Thank you, judges.
Well, what do you think when the amendment was made in 2015? What do you think the intent of the legislature was?
I think the intent of the legislature was to make sure that courts did not group something like this into scoring OV7. They wanted to make sure that the first three, the sadism, torture, and excessive brutality, was an adjective to the fourth prong. They said similarly egregious conduct and refer back to prong 1, 2, and 3 to specifically let the courts know it has to be something that is torturous, brutal, that type of conduct, or very, very similar to it. Thank you.
Counsel, I guess to the point of, it being sort of a relative inquiry. Because, I think there's a couple of different ways you can look at this, right? You can just see, here's what happened. And you can say, yeah, that's a disturbing event. That's not anything anybody wants to have happen in their life. But we see a lot of those events in this court. And certainly we see ones that are a lot more violent and a lot more damaging in lasting ways. So that's, one way you can say, well, that's not excessively brutal when I think of in that terms. But then we have, I guess the more maybe offense specific way of saying, well, what we have here is a certain kind of offense that really doesn't take much, if any, physical violence. You have an assault that doesn't require any physical contact, just the threat of it. And then you measure this relative to that. So why is that not the right inquiry to say, okay, well, what's excessively brutal is based on sort of the offense here rather than sort of a broader sense of the offenses we tend to see.
I think that is a dangerous way to view the facts of this case, because the whole reason we have case law is to look at the facts and compare the facts to this case and then apply the law. And for instance, in Lydic, there was repeated, the word repeated is very important, threats to kill. There was one threat to kill here. And then the grandson ran out and
that was also a much more like the baseline level of violence you need to commit the offense that provided the basis for a conviction was also a lot higher. So doesn't it stand to reason that you may need more brutality to be excessive in that context than you would in this context?
I don't think so, because I think that each case obviously is on its own facts. But as a grouping, we need to look at the grouping of facts and determine, even though there was a threat to kill, and this was basically a simple assault and battery, that doesn't give rise to scoring OV7 here. I don't think that we can look just at these facts and then judge it with OV7 just here on these facts. Because if that were the case, I think that then all of the cases would score OV7 at 50 points. And it's a scary thought from the appellate perspective that a threat to kill coupled with an assault and battery, whether it was a severe assault and battery or a simple assault and battery. Here, shoving is basically a simple battery. There was no, it was a shove. The threat or holding the computer up over the head is a simple assault. Not severe in and of itself, but the fact that there was a threat to kill coupled with that did not give rise to the conduct that is defined in OV7. Especially for prong 4, because prong 4 does go back and look at prong 1, 2, and 3 to determine and define it and determine whether those facts actually meet the prongs of 1, 2, and 3, or similar conduct.
Yeah, they didn't make it easy, right? But they definitely meant something. Okay, anything further?
Yeah, I want to ask you just a purely academic question. Really has nothing to do with this case.
Oh, yeah.
But I know you're very experienced, and so I'm just curious, if you were in the legislature and you had the opportunity to amend the statute that pertains to OV7, would you perhaps get rid of this all or nothing approach and create other degrees? Or would you simply, I don't know, get rid of the fourth prong, the other similarly egregious conduct? Well, and if you don't know, it's fine to say you don't know.
Boy, that sounds like a law school question, Josh.
Yeah. I've just been thinking about it a lot lately.
Well, I think the fourth prong is necessary because, there might be conduct that definitely, first may not be torture. We all maybe define torture differently. Maybe we define torture as, putting a rope around someone's neck and pulling it, or strangling them so much that they lose their breath and maybe become unconscious. Sadism, tying somebody up and threatening them with a knife, or maybe cutting off their finger while they're laying. There's a lot of horrible things, but I do think we have to have that fourth prong because we don't necessarily have the rope or the cutting off of the finger, what we consider the basic definitions. So yes, I do think it's important to have the fourth prong. But I do also think that the fourth prong needs to be viewed in light of prong 1, 2, and 3, because that's what it's meant to do, is score for similarly egregious conduct. A threat to kill with even the other facts here is not similarly egregious conduct. And I don't see it that way.
Okay,
and I
thanks.
don't think the judge properly scored OV7 at 50 points.
Thank you.
Thank you, Counselor. Well argued on both sides. Thank you, Mr. Walton, for facilitating. Absolutely.
Thank you.
Have a good day. We're going to take a short recess right now, just about 5 minutes. Great, you may be seated. Thank you. Okay, we are not quite at our 11 a.m. session yet, and I won't repeat all of my opening admonitions, except just a reminder for cases that involve children or vulnerable or protected individuals. Please don't use those individuals' names on the record, but instead refer to them by their initials or other non-identifying information. So with that, we are ready to move on to item number 5 of the morning. That's People v. Malacone, case number 371-852.
Good morning, Your Honors. I think it's still morning. If it please the court, Mark Krieg on behalf of Mr. Malacone. I've always believed that the real purpose of oral argument is to answer questions, and I am happy to do that. I would like to say a few words before we get into the questions, if the court doesn't mind. MCOA 768.27b makes clear that propensity evidence is not admitted automatically, although certainly propensity evidence, the court has the discretion to allow it, but it must be balanced under 403, and that's specifically provided in the statute. In this case, Judge Sabaugh didn't even refer to 403 when analyzing this issue. If you look at his order, he never mentions 403, nor does he even talk about more prejudicial than probative. But it seems to me that if the statute says there are times when the similar act evidence should not come in, this would be the case. This had nothing to do that the tragic death of Miss Malacone was not related to the prior acts of domestic violence. And if you look at People versus Watkins, they list 6 factors that you should look at. Dissimilarity, and I can't imagine a case that would be more dissimilar. The prior acts of domestic violence were directed at Miss Malacone, but in this case, Mr. Malacone was not the one that fired the fatal shots. Temporal proximity, some of it was closer, some of it wasn't. The frequency, there were basically 3 instances of where, or 3 different witnesses testified about the prior domestic violence. Intervening facts, I don't think that applies here. The lack of reliability, there was nothing to challenge the reliability of the other act evidence that came in. But the 6th one, the lack of need for the evidence, that to me, that and dissimilarity are critical in this case. There was no need for this evidence to come in. While the facts about whether Mr. Malacone was acting in self-defense or not, those were in dispute. But what's not in dispute is the need for this evidence, because we know that there was an affair, that he went to the house to confront Mr. Giannoni about the affair, and those facts are not in dispute. So what was the need to bring in this propensity evidence? Because the facts, the actus reus in this case, as pointed out in the brief, is divorced. It's not a case from the facts. This is not a case where he did it once before, so now he's doing it again, because he did not fire those fatal shots. So I can't, if this case doesn't meet the more prejudicial than probative, I can't imagine when you would ever exclude prior acts of domestic violence. If the court has questions about that issue, I would like to address them.
The court did exclude quite a bit of evidence that the prosecutor wanted to bring in, correct?
Yes, his drug use, but that wasn't under 7, and he did talk about more prejudicial than probative, which he did not do in this case. He never employed a balancing test, but that's not what we're talking about, whether the drug use should come in or not come in. What we're talking about is whether or not under 768.27b, whether the evidence was more prejudicial than probative. And again, given that he didn't fire the fatal shots in this case, I can't understand if this doesn't meet the more prejudicial than probative, what set of facts would?
It is an unusual case, I agree.
Yes.
Very unusual.
And the propensity evidence is so much different than what occurred here. And it painted him,
Well, I guess counsel, so what I'd like to hear about a bit more is, and I think I understand your evidentiary argument and the 403 application. But the next step is harm, right? And I understand, propensity evidence always, carries harm. But in terms of the verdict here, which was voluntary manslaughter, charged with felony murder, ultimately convicted of a lesser included voluntary manslaughter. How do I know that, to the extent there are some pieces of prior domestic violence that really shouldn't have come in, that led the jury, or reasonably likely that they led them to convict him of voluntary manslaughter rather than something less than that, or an acquittal, based on the facts that they had before them and the evidence that, was untainted by any of that?
well, he may have been acquitted of the voluntary manslaughter, but I think it's more important. I think it spills over into the assault with intent to murder conviction. I mean, here you've got this evidence that basically, for lack of a better term, painted this guy as kind of a monster in the way he treated his wife. And so if he's prone to violence against his wife, then he's prone to violence against the victims of the complainants in the assault with intent to murder. And in fact, Judge Sabaw said it's not even admissible as to the complainants in the assault with intent to murder. It's only admissible as to the felony murder. So I think it makes him look like he's just a violent guy.
But is there a prejudice argument with respect to voluntary manslaughter? I want to understand that, or a harmlessness argument. Where's the harm on that verdict from this prior? Like, how do I know that verdict that he was guilty of voluntary manslaughter based on the evidence that they had with the testimony and the video and things that were, reasonably not in dispute? How do I know that verdict was unreliable by virtue of these prior acts of domestic violence? I mean, we can go, conviction by conviction, but I'm curious about that one.
Well, because it left the jury with the impression this guy is just, and it sort of morphs into the second issue, but that he's just a man that is prepared to do anything, put his wife in harm's way. And given the prior facts of the domestic violence, that he's just this uncaring, unempathetic human being, and that they had to convict him of something.
Well, wasn't there evidence to that effect just in the course of the conduct that would have supported that conclusion, that he was a guy who was clearly very upset about what had happened and did not seem to have particular regard for the lives of the individuals who have been involved in it? I guess, how does the prior domestic violence evidence here meaningfully add to that in a way that says, yeah, that I can think that's likely to have changed?
Because it paints him as a terrible human being. And that permeated the whole trial, having read the transcript. And basically in closing argument, and I quoted a little bit of the closing argument in the brief, the prosecutor basically says that here is and so some conviction as to his wife, I think, given those prior acts of domestic violence, would have probably been inevitable. You take those away, it becomes a completely different case. And at least having tried 75 criminal trials, you just can't ignore that kind of evidence. I mean, look at what the evidence was. It was shards of glass, choking, stepping on her neck. I mean, that makes him look like an unfeeling, uncaring human being. And that's not what this is about. It's about getting a fair trial and whether or not this evidence was more prejudicial than probative. And I just don't see how one can argue with a straight face that given the facts of the case, that he was not responsible for the fatal shooting, that it didn't have an effect on the jury's thought process. So I don't know if that answers your question, but
Okay.
I did my best.
Understood.
Let me talk about the second issue. I have conceded in the second issue that bringing your wife could have created a high risk of death or great bodily harm. But what I don't think that the evidence showed is that it was likely that someone would be killed and that the defendant knew it was likely. And had that directed verdict motion been granted, although it was never made, and that's the ineffective assistance, then all of the domestic violence evidence would not have come in at all, and a mistrial would have had to been declared, because Judge Sabaugh specifically stated in his opinion that it was not admissible as to the other crimes, only as to the felony murder. So I just don't see how you can say that death was the likely result and that the defendant knew that it was the likely result. And I think that although Judge Sabaugh denied the motion, disagreeing with me, I don't think as a matter of law it reaches to that level. And if the court has any questions about that issue, I'd be happy to try to address them.
Questions on that one? No? Okay.
I'd also like to just reserve 5 minutes for rebuttal.
Sure. Yep, you have it.
Thank you.
Thanks, counsel.
Good morning, Your Honor. May it please the court, Emil Sama on behalf of the people. Of course, we have a lot of briefing. I'll answer any questions you have off the bat, but I'm going to respond to a couple of things that the brother counsel stated regarding the other act's evidence. I simply disagree that this is a 403. I actually am of the matter that I probably would have, if I were a judge, I'm not, I probably would have been made under 404B rather than 768. But the idea here, and what the prosecutor specifically did, is he never painted him as a vengeful beast. He didn't try to argue that this was a monster coming to kill everybody. He argued the nuanced argument this went to a state of mind. What the prior act's evidence did, what the judge allowed in for the homicide charge, was to show that basically this was the complete picture. His rage at what happened with the affair, his rage at what was going on with the wife and the other Mr. Giannone, and the fact that he assaulted her prior to going with her to go after him next.
But it's so dissimilar. It's very dissimilar.
Dissimilarity is one of the factors, unfortunately. I agree that there is a dissimilarity only if you take into account that the dissimilarity is he went after his wife and then later he went after Mr. Giannone. The dissimilarity is what he used a weapon in one area and maybe glass and fists and choking in the other. But the purpose, why he did those acts, is what puts it here, very similar to what DeMarsick used to do in CSC cases, to explain the motivation, the state of mind of the defendant, why he went after Mr. Giannone, and specifically why this went to the intent element of the homicide charge. Because as brother counsel argued, that there was no way for the defendant to know that this would create the likelihood that it did.
All that didn't need to come in to prove that while he was committing the felony home invasion, he acted with wanton and willful disregard of the likelihood that the natural tendency of his behavior is to cause death or great bodily harm. I mean, that you had all the evidence on that, not you, but the trial prosecutor. And I don't understand why it would be necessary to talk about all these acts from the past that really had nothing to do with that night. It wasn't necessary. So that's the problem.
I would say, even respectfully, I would say that this puts into picture and the complete picture of the defendant's motivation, his state of mind of why he went after Mr. Giannone, why he dragged his wife along for the ride. And that's what put
Well,
the
I think
situation in
they
this.
knew that. They knew it was all about the affair, and he had found out about the affair and he was enraged, and all that came in, rightfully so.
Correct.
But I don't see why these past incidents could do anything but paint him as a very bad person. And I have to agree with defense counsel, but then that was used in the closing argument and reinforced.
True, and you did say, I'm not trying to paint him as a vengeful monster, but even taking that into account, I don't believe that there's prejudice here. Again, he wasn't convicted of first-degree murder or the second-degree murder. He was convicted of the voluntary manslaughter. And taking that out, and I disagree that the judge allowed it in for the homicide charge, but it would not have been, well, that's neither here. Let's assume it's incorrectly, like your honor has argued that it should not have been admitted. I don't believe the prejudice prong here, or not prejudice, the harmlessness argument goes in favor of the defendant, because here, even taking that out, he was still convicted of the lowest homicide count of the involuntary manslaughter, which bringing that into play, and the fact that taking that out into place, he opens fire on the defendant, he chases him around, or the victim, he chases him around. But what led this is he goes back to his car, takes out another gun, and starts firing from the car where his wife is. And his argument is, nobody should know that was going to happen, that was not a likelihood that the defendant knew was going to cause her death. That almost goes to the point of ridiculousness to say, if I'm shooting from a car where my person is right next to me and the person has been shooting back at me all this time, I don't know somebody's going to be hit in that shootout. I don't see how you get a different verdict from a jury, even taking out that stuff, even arguing that should not have been admissible.
But I think defense counsel's arguing, and I think he might have a point, that this evidence about, what a bad person he was by, trying to strangle his wife, putting his foot on her neck, could have also spilled over into the other conviction for assault with intent to murder.
But again, it was used specifically to deal with
It was supposed to be.
yes.
But
And
can
we
jurors
presume
get
that-
that out of their mind?
We presume the juries follow their instructions, and when the curative instruction was given, we presume that was the instruction that they followed. And assuming, and what defense counsel is asking you to do is assume the other way. Throw out the presumption that the juries followed their instructions and that it was not used for the proper purpose, especially with the prosecutor's argument that he was trying to basically nuance his state of mind argument as the other act's evidence, even with that one part of the closing argument. The entire purpose of this was to show why the defendant went after what he did, what his state of mind was, and what his intent was. And the fact that he argued as part of the intent and the jury disregarded that for first-degree murder and second-degree murder shows that the prejudicial effect did not have what defense counsel thinks it had. And therefore, I think there's no harm. And moreover, I would submit that you would not see the harm in this one to reverse the voluntary manslaughter. I don't think it even went to the A1 charge, because again, we presume the juries follow their instructions. As to the second part, the ineffective assistance of counsel, I think this is where we have to remember what we're talking about, because I know brother counsel was arguing that there was no way for the defendant to know that the likely possibility of the person first, as I said before. I don't think that that's really a logistical argument or a logical argument, given the fact that he's firing from the car after multiple rounds of chasing him around, shooting at him, hitting him twice in the garage, coming back to get the second gun and shooting from that car back and forth while she's hit. But what you also have to take into account is this is based on an ineffective assistance of counsel claim. And the ineffective assistance of counsel claim is predicated on brother counsel or trial counsel should have made that argument on directed verdict. At the Ginther hearing, it was testified to the argument we made by both defense counsel was the one that we felt was the strongest, which is a legitimate trial strategy to make the argument they believe was strongest, both on directed verdict as well as at the trial. And the legitimate argument they thought they had was causation. They believe causation was their strongest argument. Even at the Ginther hearing, when Mr. Rabot was trying to argue, I probably could have made it. He was, even when questioned by trial judge, was making it more on the basis of hindsight than he was at the time. Because as Mr. Torres and Mr. Rabot said, we believe this was our strongest argument. Our strongest argument was this. That was legitimate trial strategy. They don't even make the first prong of the ineffective assistance claim. Therefore, most times we don't even get to prejudice. But I don't believe you make the prejudice prong either. So basically to argue that counsel was ineffective for not raising that very nuanced and very legally interesting claim as to the knowledge of probability and likelihood that somebody would be killed, they made the argument on causation, which was a valid strategic decision. And therefore, the ineffective assistance claim cannot be found to have been in defendant's favor. Are there any other questions?
Thank you.
Thank you.
No, thank you.
Opposing counsel made the best argument for me. He says it was admitted to why he went after Mr. Giannani. The domestic violence had nothing to do with why he went after Mr. Giannani. He went after Mr. Giannani because he was having an affair with his wife. The domestic violence has nothing to do with that whatsoever. That evidence, as you pointed out, Judge O'Brien, was all there. There was an affair. He was upset about the affair. He went to confront Mr. Giannani. What does the domestic violence have to do with why he went after Mr. Giannani? It has nothing to do with it. And it wasn't necessary to show that. We had all the facts that was necessary. It was the affair, not the domestic violence that caused him to go after Mr. Giannani. I do want to just comment briefly on that jurors are presumed to follow the instructions. That's true. They are presumed to follow the instructions, but there's a plethora of cases that say, despite that, some evidence is so prejudicial that we are going to reverse the case regardless of a limiting instruction. And I think this case meets those facts. It just painted him as, like I said, for lack of a better word, as a monster in the way he treated his wife. But that had nothing to do with why he went there that night. Unless the court has questions, I'm prepared to sit down.
Thank you.
Thank you.
Thanks,
Thank you.
counsel. Okay, that matter will be submitted. Moving on to item number 6, Williams v. Detroit Athletic Club, case number 375-226.
All right, good morning, Your Honors, and may it please the court. Jared Reardon on behalf of the plaintiff appellant. I'm just going to keep this relatively short and sweet for all my people in the 11 o'clock case call, hopefully. I'm mostly going to rely on our brief, except to just touch on a few of the really key points on the trial court's erroneous decisions as to the premises liability claim mainly. And that's the main theme that this court should take away from that, is that the trial court improperly usurped the role of the jury, particularly on the main inquiry as to premises, which is whether there was constructive notice of a dangerous defect, of a dangerous condition, I should say, of the whirlpool stairs. And I'll start with constructive notice because that was where the trial court's analysis really was. And I think the trial court just frankly ignored the evidence that the plaintiff presented. It gave a very cursory analysis of 1 or 2 sentences at the conclusion of its opinion. And I'll just go through the evidence that the plaintiff presented that I think presents a jury question on this issue. And that first is defendant's own manual. Their own training manual states that the attendants or the employees are to check the whirlpool deck area every 20 minutes. We have testimony from both the locker room manager and the attendant who was watching the area on that day, on the day of the incident, that these were not followed. The locker room manager stated in his testimony that the attendant should always be in the wet area, always walking through, and that if they spot water or debris on the ground by the area, they're expected to dry it up and clean up any debris in the area.
Counsel, I don't want to derail you, but can I ask you just a higher level question?
Yeah, of course.
Is, we're talking about notice, and it seems like it's important to know notice of what, and obviously that gets to the dangerous condition point. But that's something that I've been trying to figure out the right way to think about in this case, because we're dealing with, a Floridan area that's supposed to be wet.
Yeah.
Right. And, is the relevant inquiry here constructive notice of the floor being wet before your client stepped on it, or just that the floor was in the condition that it was when he, being wet, as he would be getting out of a hot tub, then stepped on that floor, wet or dry, and then slipped because it wasn't in a safe condition for a wet person to be stepping on?
Yeah, and that's a great point, Judge. I think this is sort of where the constructive notice and the dangerous condition elements sort of intertwine slightly. And that's where the dangerous condition we're alleging is that there was no protective area on the floor at all. There was no protective like matting, for example, which is what our expert stated, and really which was
in the disclosure.
Yes.
That was attached to your response to the MSD.
Yes, exactly. So that's really our issue, is that there was no protective matting, and that when the water, which of course this is a whirlpool deck area, water is to be expected. And frankly, I think that goes more in favor of the plaintiff. It shows why defendant taking reasonable steps to mitigate any potential of slips and falls is important, and why their breach is particularly egregious here, in that they didn't have any protective measures on the floor, and that when the floor would be wet, as is an inevitability, a slip like this was allowed to happen and cause injury to the plaintiff. I'm not sure if that answers your question fully, but
No, I understand. But yeah, it occurred to me in trying to think through this case, it matters what you needed to have notice of or should have had notice of.
yeah, exactly.
And this strikes me, and I'll be interested in hearing opposing counsel's thoughts on this too. Okay, thank you.
Yeah, so I mean, that's the main points I had on constructive notice is the testimony of the locker room manager saying that they were supposed to be checking the area every 20 minutes.
Can you
Oh.
help us paint this picture a little bit? Because you've explained in your brief that there was an area prior to this incident, there was an area where defendant actually did put down the slip resistant material, but it didn't extend to this area where this accident happened. So can you kind of describe where it was and, just kind of paint that picture for us?
I don't want to aver more than I have off the top of my head, but my understanding of it is that in this area near the spa area, there are some mats, but it just doesn't extend closer to the stairway area. That's my understanding of it. But again,
Or it didn't back then?
yeah, it didn't back then at least, or it didn't at the relevant time.
Thanks.
Yeah, of course. So that's the main issue on constructive notice. I also already touched on dangerous conditions slightly, and the trial court's analysis didn't really address constructive or dangerous condition at all. It turned completely on notice. It just stated plaintiff failed to show notice of a dangerous condition. And again, the dangerous condition, the wet floor was allowed to be particularly slippery and dangerous because there was no protective matting, as stated by plaintiff's expert, John Lohoff. And that's our main arguments. That's what plaintiff has shown, that there's at the very least a jury question on these issues. A reasonable jury could find that there was a dangerous condition that defendants knew or should have known if they were following their own training manual, which the locker room attendant at I think his name was Michael San Diego, testified he was not following the 20-minute rule. He was not checking every 20 minutes because there was only a certain number, I forget the number of people who were on duty at any time, but he was only checking, I believe it was every hour or so.
But here's the thing, Cal. I mean, if they can be checking very regularly, but if the area is in usage, right, people are using the hot tub, so people are getting in and out, you check every 20 minutes, it's going to get wet, right? And I think that's what, we've established. So on the one hand, I'm not sure if the inspection regime necessarily tells me a whole lot about the notice, but it also, I'm not sure, means that there wasn't constructive notice of the facts that the stairs and the floor just were the way they were. And it doesn't seem like there's any dispute that the defendant knew they were that way. It's just a dispute of whether that was dangerous.
Yeah, and I think that goes to exactly the main point of what the plaintiff's actually asking this court for. This plaintiff is not asking this court to decide whether or not affirmatively, that the checks would have for certain given them notice. It's more, the plaintiff is stating there's a jury question. Jurors could disagree with the facts presented as to whether, if they had been making these proper checks, whether they would have seen the water and whether they would have cleaned it up per policy.
Yeah, but the case law tells us that doesn't matter. I mean, if you look at Clark, you look at Banks, it doesn't matter if they actually inspected or not. When it comes to constructive notice, what matters is how long was the dangerous condition there, right? In Clark, it was about an hour. In Banks, it was just a few minutes. Both of those cases involve constructive notice. I think your failure to inspect argument is really an issue of breach. It's not an issue of notice.
Yeah, that point is taken. I mean, I think it goes to notice. I think it's a relevant inquiry in notice. Maybe not perhaps everything, but I think it's just a very particularly persuasive element to show notice. So that's the main points I have on this, unless the court has any other questions.
Anything for right? No? Okay. Thank you, counsel. You have some time for rebuttal.
Good afternoon. May it please the court. Michael Cook on behalf of the defendant, Applee Detroit Athletic Club. Judge Wallace, on the record in terms of the setup of the DAC's spa area, the matting was on the floor below the steps up to the hot tub area. There's no matting on the steps up to. There are handrails going up on both sides. And as you get to the top there, in terms of
back then.
yeah, at the relevant time, right? So because anything that happens afterwards is subsequent. Measure,
Not necessarily. It's only a subsequent remedial measure if your client admits there was a dangerous condition. Otherwise, if they contest that, then it's not remedial. It's just something they did.
Right.
So I think in your case, isn't your client contesting that it was the issue of whether it was a dangerous condition or not?
Yes, that was one of our arguments. So, and I do want to address Judge Mariani, your question about what is the danger. And in premises liability, the standard is a duty to protect of an unreasonable risk of harm. So that has to be notice of that unreasonable risk of harm, right? And that's not, in this case, that is the particular water that they slipped on. Notice of that water is that's what caused the harm.
But this isn't like a grocery store though, where you're walking down an aisle and there's a spill and that's not supposed to be there. I mean, we're in a space where, if it's being used, if it's open for business, it's being used for people getting in and out of hot tubs and they're going to be wet. So, I mean, are you saying that the floor needed to be wet already before he got out of the hot tub wet to make it so?
I'm saying that they need to introduce evidence that there was constructive or actual notice of that water that he slipped on. And the reason I'm framing it that way and arguing it that way is it wasn't dangerous when it's in the normal condition that it was. And we know that because Mr. Williams entered the hot tub hundreds, maybe over 1,000 times. Other DAC members used it hundreds of thousands of times. And the testimony is consistent and undisputed. There was no prior incident with this floor. So to argue that it in and of itself is a dangerous condition, meaning tile in a spa or shower area of a club or a home or what have you poses an unreasonable risk of harm, I don't think it comes to that point. So for them to make the point of notice of what do they need to show notice of, it's this accumulation of water that Mr. Williams slipped on. And there's no testimony, there's no evidence of the timing of when that was formed.
But I mean, he got out of he was using the hot tub, right? So he was wet, right? So they had notice of that. This wasn't like a closed area. There was somebody was not right. Hot tub was open for business.
That it was open, sure.
Yeah. So he's in the hot tub. You have constructive notice that members are in the hot tub and that they're going to get out of the hot tub and walk up the stairs and they will be wet. So why is that not?
Well, I mean, notice? They could get out, they could towel off and not be wet at all. There could be no accumulation of water there whatsoever. The salient point I think here is that water could have come from Mr. Williams himself. And that's the problem for the plaintiff in terms of showing when that accumulation of water formed.
But does that go to, I mean, why can't the water come from him for purposes of notice?
Because if he's getting out and walking straight to those stairs, that's forming in a matter of seconds. We have no notice of that. They can't protect him from the water coming off his own body.
I guess, right, you can't clean up that water that's on him. But I guess that's the point of like the slip resistant stuff is that that you aren't going to be able to, dry the area all the time. So you take other measures to make sure that it's safe for things that are wet.
And I'll circle back, I guess, to the point of why they need notice of this particular accumulation of water that apparently under plaintiff's theory was an unreasonable risk of harm is that there was no harm to anybody in decades of people using this area.
Well, we don't necessarily know that just because your client, hold on. Just because your client testifies that they're not aware of somebody slipping and getting hurt doesn't mean that nobody ever slipped and get hurt. It means exactly that. It means that the people that testified said they weren't aware of that ever happened. Those aren't the same thing.
Your Honor, I
guess if you had 100 years of surveillance and you could go through and show that nobody ever slipped on that floor, then yeah, you could make that argument. But your argument is based on our evidence, we're not aware of anybody else getting hurt.
I guess we're going to have a fundamental disagreement on that in terms of summary disposition, burden, and standards, where we produce evidence that there is no history of any prior instance here, and they
Well,
have not.
but that's
come forward
different.
with
That's
additional
different than
evidence.
saying that it literally never happened. I mean, you
Okay.
can't say it literally never happened
Then
because you
I'm
don't know.
speaking. Yeah, sorry. I'm very sorry, Your Honor. Continue. I didn't mean to cut you off.
No, I guess my other question is how long before this accident happened, how long before that was the slip resistant materials put on the floor?
I don't know
Talking
the,
years.
I don't know the answer of when the slip resistant was on the lower area. I'm sorry.
Okay, but I mean with regard to it certainly didn't get put down that day, right?
I honestly don't know, so I can't say yes or no. My guess would be it wasn't, but I can't.
I mean, at a minimum, it took as long as it would have taken to install that stuff, right?
I'm sorry.
At a minimum, that slip resistant material would have been there as long as it would take to install that material, right?
Sure.
Can we at least agree on that? And the reason I ask is because essentially that's what their expert is saying in his affidavit. He's essentially saying at some point in time, they put down this slip resistant material because they knew that this floor needed it, but they didn't put it down in the area where this person fell. So they had notice, that it was dangerous and they didn't put this stuff down. And under Banks, you got a couple of minutes, and under Clark, you got an hour.
I think there's a difference between that lower level and the steps, because the steps have the handrails going up. Also, putting material on a step can create a trip hazard with that material there. So I don't think simply putting it down on the lower level admits that the steps are dangerous in themselves. And again, I go back to the history that we have in the record for summary disposition purposes of no prior incidents. I think that is significant.
I mean, I guess there's always a difference between whether it's a good case and whether it's a jury submissible one. And I guess for purposes of the latter inquiry, jury submission, does the absence of a prior incident, is that legally dispositive?
I think in connection with the fact that this is a commonly occurring condition being
I can see that would be persuasive to a
flooring.
fact finder, maybe saying like, listen, you've been doing this, and maybe that results in no liability, but
Sure.
It's just whether we can decide that doesn't matter of law now based on.
And I think you can, based on the record, in addition to the arguments in my brief about why the expert testimony really isn't relevant on that particular question. It's a common sense question. Was it dangerous? I do think the history of it is compelling. I think the fact that it is a tile floor in a spa area, which is a common condition throughout everywhere, including homes, right? Most homes, I think, have tile flooring in the bathroom because water gets on it, right? It's not carpet because the carpet would get wet. It's a common condition. So that's what I think pushes us to no, that is not an unreasonable risk of harm, which is really the standard in premises liability case. And I do think that's something the court could say as a matter of law. The reason I think you might need to go further for the notice is the theory that there was a particularly dangerous accumulation of water there. And that's where they can't establish how long that was there, a sufficient amount of time to establish constructive notice under all the cases that I've cited. That do go through when you lack that sort of more precise timing evidence, you cannot establish constructive notice.
So you mentioned that putting down slip resistant material on the stairs could create a trip hazard. Is that something that your expert opined in this case, whether it be in testimony or in an affidavit, that those stairs should not have slip resistant material because it would make them dangerous?
I don't believe so, Your Honor. And I just point that out for the purpose of the significance of the lack of prior history of falls there. There's not a compelling need to have it there when, in addition to putting it there, it could create an additional hazard. I don't think the expert testimony is even expert testimony on whether or not this was a hazardous condition, the type of which premises liability law would require additional measures. Because it is, in the case I cite was Gilbert, which involved an expert testifying to a very common knowledge scenario. I think this is the same thing.
Do you agree with the assertion that I made to fellow counsel here that the issue of whether or not they inspected the area or not is completely irrelevant to the issue of notice?
I do agree with that.
I mean, it could be the opposite. If someone inspected and they did see something, that could be it. But the failure to inspect has nothing to do with notice under Michigan law.
And I think Lowry is spot on for that. that case is really what kind of set that in, sort of black letter law, that the notice analysis does not get into whether or not the defendant did a reasonable inspection. Those are two separate concepts. If you have any further questions, I'm happy to answer them.
Okay, thank you, Counsel.
Thank you very much.
So counsel, one thing that your fellow counsel here argued is that you have literally no evidence to show how long this particular puddle of water was on the ground. What do you say about that?
That's exactly where I wanted to go first. And I will say that the inquiry of this particular puddle is not particularly relevant here because the dangerous condition is the lack of the mats on the area, the slip-resistant mats. As Judge Mariani stated earlier, it's a whirlpool area. Obviously, people are going to be consistently getting in and out of it. They're going to be dragging water with them. And without the mats in the area, that is the dangerous condition. There's no mats on an inherently slippery space.
What's your response to his argument that, your client had been going there for 30 years and he'd never slipped on this thing before. So how all of a sudden is it a dangerous, not just dangerous, but an unreasonably dangerous condition the day that this happens?
For that, I would rely on the statement of our expert that he found that there was an unreasonably dangerous condition because of the lack of matting. And I would also state, just because one hasn't, I guess for lack of a better word, fallen victim to a dangerous condition in the past, doesn't inherently make that not dangerous. It just means the danger hasn't yet been activated on that person. So that's what I would say in response to that. And finally, unless the court has any other questions following up, I'll state that brother counsel stated towards the end of his argument that in response to the expert trip hazard question you had, Judge Walls, that there's no compelling need for slip mats. And that's where, again, I would point to the dueling experts we have here, where their expert may state that there's no need for slip mats, but Mr. Lohoff stated that there is, that it violated industry standard. That there should be these slip resistant mats to prevent unnecessary falls on.
Did their expert actually opine that there shouldn't be slip resistant mats there? I think he had made the argument that perhaps certain types of mats could cause a trip hazard. Was there any opinion offered by their expert in that regard that you remember? I'm putting you on the spot here, so if you don't remember, it's fine.
Yeah, I don't remember off the top of my head, so I don't want to make an averment either way there. But even if he did, I think that would still be dueling expert opinion, which would present a question of fact for the jury. As you stated, Judge Mariani, there's a difference between good cases and jury submissible cases. There's plenty of evidence I'll concede that brother counsel has that may play well in front of a jury, but I don't think that the trial court acted properly in taking that question away from jurors. So unless the court has anything else, any other questions?
No, thank you.
Thank you very much.
Thank you, counsel. Thank you both. Okay, that case will be submitted. Everybody still. All right, so we will move into our nominally 11 a.m. Session. And that brings us to item number 7, which is AZ Electrical Engineering v. Jenkins, case number 374949. So I see that does not appear that the appellant is endorsed. Is that right? And appellee is endorsed, however? The appellee is endorsed, however, correct? Okay. Counsel, is that you? Are you, I'm sorry? You're here for the appellant? I see. Okay. So you're not endorsed for argument. Okay.
No questions. Thank you.
Okay. It doesn't appear there are any questions from the panel, and it does not seem that we have appellees counsel present. So if the panel is comfortable, we will submit this one on the briefs.
One second.
Okay, yeah, we'll
you don't
hold that.
mind. Okay, thank you.
Okay, that matter will be submitted on the briefs.
Thank you.
Okay, moving on to item number 8. And that is Progressive Marathon Insurance v. McDowell, 373228.
Good afternoon, Your Honor. May it please the court. My name is Tim Deemer. I'm here on behalf of plaintiff appellant Progressive. Also with me is Emily Smith, the new attorney from our office, just to attend. Hope to have her come to a few before she handles them on her own. She's brand new with us.
Great, welcome.
I'll be very brief. No opposing briefs were filed. I also tried to warn, Emily, that isn't your typical court of appeals argument. There were no briefs filed by the other side. No one endorsed for the other side. So I'll be very, very short. And just, I think the statutory language controls the outcome here. The trial judge said that the PIP selection by Dwight Harvey only applied to him, didn't apply to anybody else. I think if you look at the text of the statute, 3107C5, the trial court made a legal error by coming to that conclusion. And I didn't file a statement of supplemental authority on the Mary Freebed versus Esurance case, a published decision from this court issued earlier this year, because it didn't address this exact issue, but it essentially took our position in this case for granted. That was a case involving a motorcycle accident, an individual named Mr. Slade, who was treated by the Mary Freebed rehab facility. Mary Freebed sued Esurance and USAA. Esurance essentially the Mr. Harvey in our situation. Esurance insured a driver named Tanner who hit the motorcycle. The question in the Mary Freebed case was whether Mrs. Tanner made an effective selection to limit the PIP coverage to 250. This court said, no, she did not. Then the court's analysis turned to a rebuttable presumption that it was 250, not unlimited, based on the policy premiums that had been paid. And this court agreed that the presumption wasn't in force. It was 250, and the Mary Freebed, nobody else contested it. And then it went on to say, okay, now USAA, you've got to cover anything above 250. The case is up in the Michigan Supreme Court on the issue involving USAA. There's no challenge to this court's ruling as to Esurance. And again, this court didn't exactly address the same issue we raised, but took it for granted. When this court said Esurance's policy was effectively is effectively $250,000, that ended the analysis. Mary Freebed got the 250. They didn't get unlimited. They didn't get anything above that 250. It was just take it for granted. So again, didn't decide the sect issue, but essentially supports our position by there's no dispute on that point. And again, I'm happy to answer questions the panel might have. Otherwise, I want to make sure to show up since we were endorsed.
What happened with what's the current status of the consolidated cases? Because this case was not consolidated with the other 4, correct?
Correct. The other consolidated cases remain pending. We filed an interlocutory appeal to this court, which was denied. We then filed an interlocutory appeal to the Michigan Supreme Court, asking the Supreme Court to remand it back and consolidate it here in the Court of Appeals. Supreme Court said no.
So, but the reason I ask is, doesn't this issue have to be considered by law in those cases? Because the order you want to appeal from here was never entered in this case.
That is, maybe they didn't want to respond to the brief. I'm being sarcastic here because they saw a 10-page statement of jurisdiction instead of the usual paragraph. It was a very complicated path to how we got here. And Judge Hathaway didn't formally consolidate the DJ with the underlying cases, but decided them together at the same hearings. The orders were referencing each other, and the final order we have here specifically refers to a September 4 order.
But your lower court file in this case does not contain that order. It's contained in the consolidated case file.
I'm going to pull up. So our exhibit F is the August 29 order. Yeah, that is part of the confusion. But the judge made rulings in, I call the underlying action, third-party actions, then carried them over and applied them here, and the status of the DJ action that we're here for.
But you know that the court speaks through its written orders. There's no written order in this case with regard to, I should say, the written order that you're wanting to appeal does not actually appear anywhere in the lower court record in this case. And if it does, definitely I want you to tell me it does, because I've looked through it and I don't see it.
Okay, so
I mean, she certainly that in that last hearing, she has all of you there. There's no doubt about that. She does say on the record that your case is not consolidated with the other ones, so she was aware of that. The written order gets entered. It only gets entered in the consolidated cases. It does not get entered in your case.
Okay, so let me walk through our appendix. We've got all the orders attached here. Exhibit A was the October 17, 2024 order issued in this docket number, the DJ. And it is ordered that this order incorporates by reference the court's order denying motion reconsideration issued on September 4, 2024. So let me then pull that one. Okay, well, then we have an order from the consolidated case, the underlying case, July 9, 2024. That's the one where the court.
That exhibit F?
Oh, I'm on E.
Okay.
And E is the one where. No, I'm sorry, you're right. That was, see, this is confusing. That was the reconsideration ruling that was then reconsidered a second time. And now we have Exhibit F saying plaintiff's medical bills are not subject to limitation of policy. We also, so a court speaks through its written orders, but we also have one of the hearings where Judge Hathaway clearly says that the $250,000 selection doesn't apply to anybody other than Mr. Harvey. And it was at one of those hearings where everybody was there, the underlying folks, the DJ folks, the coverage folks were all there. She did make that ruling. And then she issued her order in this case, Exhibit A, said it's final. It was actually, she had to hold a hearing to clarify.
Well, we're not suggesting, or I'm not suggesting you didn't appeal a final order here. That's not the issue. The issue is that the written order that you're complaining about in this case was never entered in this case.
Okay.
From what you say, those other matters are still pending. So it would seem that you still have the ability to obtain relief here. Although I don't know about that, and I'll tell you why. Because if I looked up the consolidated case number, I didn't look up all the other three ones, but they had the one case number that the court was using as I forget what you called it, and you mentioned it in your brief. It was called the controlling case number, I think you said.
Okay.
So I looked that up, and that case was administratively closed just last month. So in other words, I don't know what happened with it. It apparently was pending for a long time and nothing ever happened. And so the court administratively closed it, but that was just last month.
It might be reflective of no one participated in this appeal, either folk filed an appearance, but then didn't really do anything with it. And the Michigan Supreme Court clerk, while that was pending, reached out and said, please explain to us what issues remain pending in these cases and which issues do not remain pending these cases. And it was like a 10-page letter that we prepared and filed with the Michigan Supreme Court clerk's office. And I believe this court would have access to that filing. It was a letter, public filing, into the record. If not, I could refile it into this Court of Appeals docket number if the court would like to address that issue, because the Supreme Court was also perplexed about what was still pending, because we have decisions, reconsideration, then clarification of the reconsideration of the summary disposition. And the Michigan Supreme Court also wanted to know what was pending and what was the status.
I know you weren't trial counsel, so you might not know the answer to this, but why didn't your client consolidate this case with the other four?
Yeah, I don't know. I don't know if they try to, and Judge Hathaway didn't want it to occur. I think that did come up at one of the hearings, and Judge Hathaway wanted to keep this one separate from the underlying. I believe it was the judicial preference, not a selection of the parties. Not 100% sure on that, but in preparing for today, I remember seeing that in one of the transcripts I looked at.
In the letter to the Michigan Supreme Court you're referencing, that was, just to clarify, in what matter, the consolidated case?
Correct. In the the consolidated case, the 5 or 6 underlying injured plaintiff, medical provider versus the drivers and the insurance companies. And the clerk reached out and just said, please explain what is still open, what's still active, and what's been decided with finality. And we filed that with the court, and the Supreme Court denied leave to appeal, failed to persuade. They didn't say, hey, this is moot or there's nothing left for us to consider. There's no jurisdiction there. It was a failure to persuade denial.
Okay, but you're telling us that with regard to that consolidated case, the one where we can see the register of actions, that case is not settled, right?
I'm sorry, it's not.
That case is not settled.
Certain pieces of it have settled. There's so many moving parts, so many claimants. But again, in our letter, there were certain issues. I believe it was one of the claimants' future medical benefits were still not decided with finality. This was a while ago that we submitted that letter, but I believe that was the case. There were somebody's future medical benefits
Well,
were not.
it was still open as of the beginning of last month when the court administratively closed it.
And I know when the court does that, they'll typically send a notice out and say, we are going to administratively close this if you don't let us know if the case is still active. I didn't have an appearance in any of those, so
Yeah.
I didn't get notice.
I was just going to say, they wouldn't have sent it to you though.
Right. We sometimes will file an appearance in the trial court, and this one we did not in the consolidated cases. And the trial counsel didn't send it to me either for whatever reason.
I didn't mean to take you off track.
That's what I was here for. We were doing for oral argument. If the panel's got questions, that's why we want to be
Yeah,
here.
that does seem like a procedural mess in potentially important ways, but that's helpful.
And it would be helpful. I'd be happy to file that letter into this docket number, or if the panel would like a clarification about when the judge's ruling on the dispositive issue in this case would have been contained in an order in this case, or if the court wants me to just leave that alone.
If there was correspondence sent by the Supreme Court, it'll be in the file. So
Okay.
we can see it.
Okay. Yep. We electronically filed something on the Supreme Court.
And we obviously, we can consult, and if there's something we feel like we need from you, we know where to find you.
Okay. All right. Also, any other questions? I'm happy to rest in the briefs. Brief.
No.
Sorry. Singular. All right,
Thank you,
thanks,
though.
Your
All
Honor.
right, thank you, Counsel. Okay, that matter will be submitted.
Yeah, I'm done.
Okay, moving on to item number 9, People v. Woolman, case number 374-806.
Good afternoon, and may it please the court, Jonathan Simon on behalf of Mr. Woolman. Mr. Woolman was charged with 3 counts of first-degree CSC, 2 counts of second-degree, and 1 count of attempt, where I guess he was literally caught with his pants down. The problems I have with this trial begin with the sane nurse who's, and I see this all the time. I don't know why it's allowed, and but this nurse is allowed to go through and just read literally from a report. Complainant said this, complainant said that, complainant said the other. And for some reason, it's accepted under the medical, I think, exception to the hearsay rule. But this is not a situation where the complainant went directly to the sane nurse for medical treatment or for diagnosis. She was sent there by the police, and she was sent there for the purpose of collecting evidence to be used against Mr. Woolman. This is not medical.
It happened long after that they were caught, correct? I mean,
Yes. And the purpose is to do a head-to-toe medical evaluation, to collect DNA, to collect other perhaps forensic evidence, to take photographs, to look for bruising, to look for scarring, to look for other acts, other physical evidence of criminal sexual conduct.
Right, but just to clarify this, but this isn't one of these. And yet we have cases where this happens, 7 months after charged conduct occurs or whatever. That's not this case.
Well, We don't really know because we know that this happened right after the last alleged incident. But we don't know
Well, as soon
when.
as as soon as the conduct came to light, this happened.
Yes.
Right.
Yes.
Yeah. Now I understand that it comprises a history of conduct that predates that, but in terms of the timing between when we have the charged conduct, some of the charged conduct discovered, and then when the examination occurs, it's a short interval.
That's correct. But other than that last alleged incident, the attempt, we don't really know when the others actually occurred because according to the complainant, it happened quote unquote every day, which brings me to the arguments 2 and 3, because every day when you're charged with 5 other counts, and we're talking about a prolonged period of time, every day involves literally untold amount of potential. It's untold potential amount of times, and so to me, it smacks of other acts evidence without notification. It also means that.
Well, there is no. I mean, if we accept that framing, sort of this is thought of as other acts, and we're talking about notice, or in this case, I mean, I think this all seems to fall pretty clearly under the statute rather than 404B, 768.27A. And then that is its own sort of disclosure requirement. But the fact that the conduct involved in this case, spanned back during this period of time, I mean, that's not a surprise to anybody. Right. I mean, that was in the charging documents.
Well, yes,
information.
The information.
So where's the lack of disclosure, I guess?
The information alleges a specific range of time. The information alleges 5 specific acts. And to say every day, going back for a prolonged period of time, it certainly involves more than 3 counts of CSE 1, 2 counts of CSE 2. Again, the only date we know for sure is the date of when it became evident, at least to the complainant's mother. And that was what triggered the investigation. That's what triggered the charges. But every day, to me, it not only gives us, I think, concern about other acts, other uncharged acts, but also the question of which acts, alleged acts, were found by the jury to have been committed beyond a reasonable doubt. Because every day could literally mean hundreds of different times. And without knowing which specific acts we're talking about, then the jury may not have been unanimous as to which specific acts they convicted Mr. Woolman of having committed. And so we have that issue too. Not only are there uncharged acts, but there's also question of unanimity. And for all of those reasons, we believe the trial was not fair and that a new trial should be ordered.
Questions? Okay, thank you, Counsel.
Thank you.
Good afternoon, Your Honors, and may it please the court, Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people. In addressing issue 1, I hear Mr. Simon say, the sane testimony of the sexual assault nurse examiner tends to come in under MRE 8034, and he's not sure why that all these statements are allowed sort of to come in. And I think the why is outlined very well in People v. Garland, that case from 2009, where it's explained that the patient's history is very important because it tells the nurse examiner how to treat the patient, how to proceed with the examination, including whether there's apparent physical injuries or whether they need to treat sexually transmitted diseases, immune deficiency, pregnancy, or other psychological trauma. The history of the assaults are very pertinent to those issues, which is part of the medical diagnosis and treatment. I think you see that here in this particular case as well. Sane Stevens testifies that she needed to know about the last known contact, what kind of contact, not only for evidence collection purposes, but more importantly, for medical treatment. So I see no issue here with the admission of that testimony under MRE 8034, I think it's very consistent with how we've seen that testimony be properly admitted before. Additionally, I think that it's important to highlight these sexual assault nurse examinations are incredibly important medical service to the victims. And while evidence collection is a part of that exam, it's not the primary purpose. And again, I think that the same nurse in this case made that clear too during the course of her testimony, that evidence collection may be part of it, but it is not why they ask these questions in particular. And I think it's worth noting that this case, Judge Mariana, I believe it was you, it is very distinct from those cases where you have an examination well after the assault happens. I think the defense in their brief relies on People v. Shaw. And in that case, you have an examination years after the last known or last alleged assault. And here we're talking about hours or within the last day of the last known sexual assault. And so the timing, I think, also plays a role into whether or not the history is important, whether it's for medical diagnosis, and whether or not the admissibility is proper. Briefly regarding the other acts evidence, it's interesting because I don't know that I read this transcript as the victim's testimony was happening every day or nearly every day necessarily as other acts. I think that that is part of her description when she's asked, does this happen one time or more than one time? This SS at the time of testifying is barely a teenager, and she's saying it happened every day. It was so frequent that it was just this pattern of behavior. But she does testify to specific incidences that I think in context of the testimony very clearly support the charges in particular. In terms of the incident in the garage, the attempted incident that her mother walks in on. Pardon me, and then there is another one. Excuse me. I'll just rely on, oh, here we go. She testified that she's around 14 years old at the time he starts touching her, that the penetrations begin when the family moves to a different house, that she testified to the very first incident stopping when her mother was first coming home. She testified to those types of things happening more than one time, but again, talked about it happening in her room, doing the same thing that just told you that it happened again. And so I think when you look at the victim's testimony, even though she says it's happening every day, she is identifying specific incidences that the charged conduct relates to. So I don't see an issue with the unanimity instruction. I don't see an issue with it being part of the proofs, or even if it is other acts. I agree that it falls under the statutory exception and not 404B, and that that victim's testimony about the frequency and sort of occurrence was well known, and so there's not a notice issue. With that, I'll rely on my brief. Sean, are there any questions that I may answer for this panel?
Anything further? No. Okay.
Thank you.
I agree that it is necessary for the complainant to give a full history to the same nurse in order for the same nurse to be able to know what to look for, what to collect, what to, how to react. And that's all fine. What's not fine is that the same nurse did not treat complainant. The same nurse did not diagnose the complainant. The same nurse only collected evidence, and that is not, I think, within the 804 rule. There is no medical treatment here. There is only evidence collection, and not by somebody who came to her for that purpose, but somebody who was directed to her by the police. And so, again, I don't believe that exception applies.
Understood. Anything further? Okay.
Thank you.
Thank you, counsel. That matter will be submitted, and brings us to the back half of our double header for you two. Item number 10, People v. Golombiewski.
I think it's Golombiewski.
374-845.
Good afternoon again, Jonathan Simon on behalf of the appellant. Mr. Golombiewski testified, and I think, let me first start by saying, I know that there was a request for some exhibits. It was received maybe about a week or so ago, and I've reached out to Ms. Stone's office, who has been very helpful. And I just got an email this morning that I think some of it has already been transmitted to me and the rest is forthcoming. So I should have that information this week, and I will forward it to the court as soon as it becomes fully available to me. So I'm asking that the court not rush to judgment because the exhibits will be provided in the very near future. Moving on to the merits of the appeal. Mr. Colombiaski's attorney had requested a self-defense instruction, and that was denied. And the judge said, well, I think it was an equivocal self-defense testimony. But I think actually, and I quoted some of the testimony, but I think Miss Stone actually did a better job than me, because on page 11 of her brief, she actually quotes some, I think, more compelling testimony where he said, quote, I reached out of self-defense and impulse to push her away. And clearly he's stating that the alleged strangulation was basically in the course of defending himself from a domestic assault by the complainant. And under those conditions, I think he had set forth a sufficient grounds for the self-defense instruction, which should have been granted. There was evidence in the testimony of my client that there was reason to believe that he did so in that fashion. And for that reason, I believe that that instruction should have been provided. The other issue I would like the court to seriously consider is the assessment of 50 points for offense variable 7, aggravated physical abuse. And while counsel did not object at the time of sentencing, I did file a motion to remand. So the issue is preserved under 769.3410.
Can I just go back for a second? So is your argument in this case that your client should have received the self-defense jury instruction, that he should have been allowed to argue self-defense, or both?
Well, I think he did. He testified there was self-defense. Yeah, he was denied the instruction. I don't recall whether there was a denial of counsel's ability to argue self-defense at closing. I think that he did. I don't recall specifically, but I do know that the judge did not instruct the jury about self-defense. And it's very important because under Michigan law, self-defense must be disproven beyond a reasonable doubt. And so it's crucial that the instruction be given so that the jury can evaluate it in pursuant to the Michigan law. And I understand that this law is something somewhat unique to the state of Michigan, but it presents a very strong and compelling reason for the jury to consider these actions. And
the counsel, I guess, perhaps in connection with Judge Wallace's statement, it seems that you do have an issue about striking your client's statement about the victim having a prior domestic violence arrest. Correct?
Yes, I refer to that as reverse 404B. Ms. Stone calls it character evidence.
Right. And I mean, is that, does that connect to the self-defense issue? I guess why was that evidence, what was it properly relevant to?
Well, his state of mind, he knows that she has a history of this kind of behavior.
Is it the reasonable apprehension of harm? Is that what you're saying for the self-defense? Like it's relevant to that?
Yes, and that was more reason I think that there was, but again, and it wasn't even something that I think his counsel was eliciting. It is something that my client, I think, wanted to get out there. And because I think even defense counsel, did not dispute the ruling and moved on. I mean, I think everybody was sort of on the same page that this is not something I was looking to get out. This is something that we were not soliciting. We were not eliciting. We were, so it never came up because the judge pretty much shut it down once the prosecution objected, because and there wasn't, I don't know, really given a good reason for it. Again, counsel here on appeal submits that it was improper because it was character evidence. But again, I believe that it looked like reverse 404B. But does that answer the question? Because I think actually it's a good point because it's more reason, I think, for the self-defense instruction. Or would have been had that testimony been fully allowed to develop. But everybody seemed okay with just moving on, despite, I guess, Mr. Golumbieski's intent to let the jury know that she has a history, and I was apprehensive, reasonably so, by the fact that she had committed domestic violence against me in the past. As far as the sentencing guidelines are concerned, 50 points were assessed for OV7, aggravated physical abuse. We don't believe that that was appropriate under the circumstances. And it did increase the sentencing guideline range from 43 to, I think, 117 up to 50 to 200. So we believe that at a minimum, there should be a resentencing. But for the first two reasons, we believe that a new trial may be more appropriate.
Anything further? Okay, thank you, counsel.
Good afternoon, Your Honors. Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people. Initially, I think it's worth noting that in the defendant's arguments, most of them are premised on accepting only the defendant's version of events. His testimony that he was struck by a curling iron, only then does he reach out to grab the victim by her neck area, that he acts in self-defense. And I think it largely ignores the other testimony that occurred at trial from the victim, which is that he's the initial aggressor, that they arrive home after an argument at a sort of 4th of July family barbecue. And immediately upon arriving home, the victim testifies that he shoves her against the wall. He begins choking and strangling her sort of in the entryway of the home. At that point, she's able to escape, runs to the bathroom. He bangs on the door. He tries to force his way into the bathroom. She does eventually open it up. He begins to assault her again. And at that point, she hits him with a curling iron, trying to defend herself. Despite her efforts, he chokes her again. There was testimony about some sexual assaults that followed after that, which of course he was not convicted of. But I think that's all really pertinent information when we evaluate these claims, and it's sort of glossed over in the way the defendant presents his arguments. So when looking at the first issue regarding, I guess, this reverse 404B, the evidence of the victim's prior domestic violence history, we do argue that it is more character evidence. It's really offered as improper character evidence that the victim once had a domestic violence, and so she has a propensity for being violent here. And I think that it's properly excluded that way.
But I guess why is it not admissible as an other act relevant to reasonable apprehension of harm for self-defense?
So that's a good question. I think first and foremost, even if we're looking at it in a 404B or reverse 404B sort of other act lens, surely there is some sort of notice requirement. In a regular 404B, there's a notice requirement before that would be admissible. Here we have none of that. I think it's apparent from the record that this is just something that the defendant sort of blurts out in some way of a non-responsive. So I think it wouldn't be properly admissible because there was a lack of notice about what the intention would be to use this evidence for. But beyond that, I also think that it wouldn't be properly admissible sort of about propensity or state of mind, because again, the other competing testimony we have is that he is the initial aggressor, that this was not something started by this victim. And I think that that's sort of wholly ignored when we talk about this issue in the defendant's briefing.
Well, right, but I mean, he's entitled to, assuming,
Sure.
I understand this is at issue too, but if you assume that self-defense, that he's entitled to make that defense, then he's entitled to proofs in that regard. And one of the elements, right, is reasonable apprehension of harm. And, the knowledge of the individual you're dealing with, that's an area that there's rules about in terms of evidence being admissible and what have you. I know 404A and 405 speak in certain ways, but I guess I don't know why it wouldn't be okay under 404B. If you set the notice issue aside, just as a matter of substantive admissibility.
And I think that's hard for me to answer, Judge, because frankly, I have no idea sort of what the nature of this prior domestic violence allegation was. So in terms of, did it go to reasonable apprehension? I have no idea. I think none of us have any idea in terms of what was that issue? Was it similar to this issue? Was it with another intimate partner? I think there's an allegation that it was with an ex-boyfriend. And so I think that the judge made a fair ruling in this case that didn't abuse his discretion because we had no information about what this other allegation of domestic violence would be. So in that light, the only possible use for it is to make the victim look bad or for propensity, because we don't have any information that would suggest it is sort of his state of mind or apprehension. So I think we don't know enough about it. And so in that way, I think it's properly excluded, sort of no matter which way we look at it. Mr. Simon didn't touch on it, but I will briefly, in terms of the insufficient evidence for the unlawful imprisonment count. I think there's sufficient evidence here. Again, taking the victim's testimony into account here, what was on the record was that this was a lengthy attack that went on for quite a while throughout the evening. And I think that's similar to what we see in People v. Wilson, that the length of attack matters, sort of the severity and egregiousness of it matters. And I think there was evidence on this record sufficient for the jury to have considered that and decided that count. Regarding the instructional area of the self-defense instruction, I don't believe that the defendant's testimony itself really put self-defense at issue. He calls it self-defense, and then in the next express says, well, it was just impulse. I just ended up grabbing her. When Mr. Lepley asked him, why did you grab her by the neck here? He says, it was just impulse. And he says, when he was asked if he squeezed her neck, he says, I might have squeezed a little bit. And again, it wasn't on purpose. So the defendant, even while he's saying the word self-defense, is describing this sort of reflexive incidental conduct that I think, as the trial court discussed, you can't have done something on accident or incidentally and intended to do that for self-defense. He sort of, I think, mixes up, his actions, whether it was an impulsive thing he didn't mean to do or whether it was an appropriate self-defense action. And so I think with that very equivocal testimony, it was not an abuse of discretion to say.
I mean, he claims, and again, this is just his testimony, but he claims he's being hit in the head with a curling iron and that he grabs the person that's hitting him in the head. How is that not a person defending himself?
I think when you end up looking at, as he continues to testify, that he also squeezed her neck, I think that even if you say maybe that's defending yourself, even if it's impulsive or that's a reactionary thing to grab her neck.
Couldn't we agree let's forget about the facts of this case for a second. If you had an individual who happened to be in the same room as somebody else and that person starts hitting them in the head with a blunt object and they grab that person by the neck and squeeze their neck to stop them from hitting them in the head with a blunt object, that person could argue that they're defending themselves, could they not?
I think that to be fair, I think that they could, Your Honor. I would probably argue that the squeezing of the neck, giving the dangers of strangulation and things like that, goes beyond what would be reasonably necessary in that situation. That if you were being hit in the head, there's no reason you couldn't have grabbed an arm or otherwise shoved. That specifically grabbing the neck and squeezing probably goes beyond what it's reasonably necessary to defend yourself in that situation. And I think those are facts that the trial court had to hear too, that it's not just a grab. It wasn't just a shove. It did include a squeezing of the neck. He's equivocal about whether he meant to do it or not. And again, I think you have to fairly balance all of the other testimony, which included him being the initial aggressor. And he can't claim self-defense.
Well, and also the other evidence, including the photographs and, the video, and did any of those corroborate what he said?
It's a great point. And my position is no, they didn't, right? This victim had significant bruising that was visible to the officers immediately upon arrival the next day. So I think all of the injuries, including the photographs, I think it seemed that it went far beyond just what was necessary to push away a much younger, smaller attacker.
Far more than just grabbing somebody with one hand by the neck and squeezing a little bit.
Correct, Your Honor. And then lastly, regarding OV7, I won't discuss it at length. I know this court has heard a lot about OV7 during today's arguments. But again, I think looking at the situation here, this was an offense that included multiple strangulations that included her being prevented from leaving the house, from her saying she tried to leave but was afraid to. Any one of those instances would have supported the charges, but this was a continuous course of conduct. I think it's clear that what the defendant meant to do was to punish her. In fact, there was testimony on the record that he made comments about doing certain actions in order to punish her. And so I think looking at the conduct, considering for the defendant's intent here in its entirety, there was a fair basis to score OB7. Can I answer any questions for the panel?
No. Thank you.
Okay, thank you,
Thank you,
counsel.
Your Honors.
Any follow?
Couple quick observations. One is that you look at MRE 404B, it requires the prosecutor to give notice. There is no requirement that defense give notice of 404B evidence. So notice is not an issue. The second thing is that if there was some question about where this testimony was headed, all the judge needed really to do was perhaps remove the jury and ask for an offer of proof, or basically ask that question, for what purpose is this being offered? None of that happened. It was just immediately shut down, and people moved on from there. The second point I wanted to make is that if the reaction to this assault with the hair curler, straightener, whatever it was excessive, I think that's a question for the jury to decide, not for the judge. The judge should have allowed the instruction on self-defense, and the jury can decide whether that reaction was reasonable under the circumstances. So in that situation, I think to say that it was an excessive reaction would preclude an instruction is wrong. So the instruction should go forward, and the jury can decide, whether or not it applies in this case.
Okay. Anything further?
No.
Okay.
Thank you.
Thank you.
Thank you.
Okay, that matter will be submitted. Okay, moving on to item number 11, Barnett v. City of Detroit, 375164. And I believe we just have appellant endorsed for a maximum of 10 minutes.
Good afternoon.
Good afternoon.
This is Linda Fagans, appearing on behalf of the City of Detroit. The essence of the question here is whether the plaintiff produced evidence establishing a genuine issue of material fact that her injuries resulted from the negligent operation of a city-owned bus, and that will fall in within the motor vehicle exception to government immunity. And the answer is no, because there's no evidence of a negligent operation. Government immunity bars this claim, and the trial court erred in denying the motion for summary disposition based on governmental immunity. When you look at the facts here, there's no disputed issue of fact. The story, I'm sure you're very familiar with. Plaintiff got on the bus, and she had some groceries. Was about to sit down, and the bus driver had a car to jump out in front of it to make a right turn onto Evergreen off of Grand River. And the bus driver had to pump on the brakes twice to avoid a collision, an accident here. It's undisputed. If you looked at her disposition, she kept saying, and she says, I did not see what happened, but the witnesses said, and she agrees that that is exactly what happened. There was no collision, no contact with another vehicle. There was no,
Counselor, as far as I'm concerned, I mean, you gave the plaintiff an opportunity to rebut your argument regarding a binding precedent, which was Selden, and the plaintiff simply ignored you.
Yes, okay, that's true.
I mean, I don't know that there's a lot to talk about.
No, because the cases purely in Selden and Gus and all of them show that these incidents, these are normal incidents that happened in terms of jerks and so forth, and there's nothing more. And then this bus stop driver actually avoided an accident. But what I would like to know, and I don't know if the court is aware of, he filed a motion to dismiss this case for lack of jurisdiction in the Court of Appeals. And I would like to address that if you don't mind. And you here, he filed that yesterday. And so you all didn't get that. Well, truly under Seldon, as you just recognized, Randy, Judge Wallace.
okay.
I was going to say your whole name. I wasn't going to say it because I'm
Let's say, counsel, that motion isn't before us, right?
Okay.
So that'll be handled in due course, but.
Okay, I didn't know whether
he
it came before you or not, and I didn't know if you had any questions before me. And you are correct. Seldon does address this, that the absent evidence or any conflict, that this case should have been granted summary disposition. No further questions from you all?
No, I don't think so.
Okay, great. And so, okay, I just wanted to make sure that you all wasn't aware of that.
Great. Thank you for the.
Thank you,
plaque.
Counselor.
Appreciate it. Okay, that matter will be submitted. Item 12, INRI NS 378-295. Neither party is endorsed, so that matter will be submitted on the briefs. And item 13, INRI Doyen Emmanuelson Minors 376682. No party is endorsed, so that matter will be submitted on the briefs. And that concludes our case call for today.